Informant.
OP number 2 informant is not issued for the time being, or is not issued at this stage. LCR be called for public scan copy. लिखन्तु IA 1304 oblique the prayers made in the application shall be considered after receipt of the LCR.
My prayers for the bail is concerned, that is considered after receipt of the LCR. That's what fine amount is concerned at the time of
subject to the appeal. So seta bada katha no. So let us wait for the LCR. Then jetu mu last occasion ne say karichi. Let me not deviate.
Normally what happened?
Yes, I got your point. But that's a valid submission. The last occasion one appeal or 1 or 2 appeals were there. So that will be considered because the other part is that this is not a regular bench. So what will be considered by the bench that will be taking up the appeal?
There is a normal practice of this court. That fine amount has been stated, but as far as the bail is concerned,
practice before the assigned bench. This is wait after vacation.
Madam.
The underlining, there is a silver lining or whatever you call it.
Madam.
Those cannot wait. Should but since he is in custody, so it has to be taken. So you move for both, for bail and both. And that is in interest of the petitioner, appellant also. Appellant petitioner. Issue notice as above. Yes. Issue notice as above first line लिखी देना. तापरे सेटा को लिखी देना तो सब. After LCR is received. तापरे notice to the OP number 2 is not issued for that at present, at this stage. Notice to OP number 2 is not issued at this stage. The matter shall be listed immediately after receipt of the LCR, oblique, moved by the appellant. Yes.
Item to
Yes.
The matter regarding.
Just kindly speak to the microphone. आपण मानकर किसी सुबुनी YouTube रे मते सुबु जैसे ना मे बी काच
Matter regarding payment of a compensation for acquisition of land for the construction of lower Indra irrigation project, Your Lordship.
Mr. Mahanti,
Similar order,
so you will take up and response.
Well, similar order.
Kindly refer to the order, Mr. Behra.
Your Lordship, page 17.
17.
Annexure 3.
Annexure 3. It may be changed.
You can correct it and be.
Yes, Your Lordship.
हाँ सेटा आपनकर कोन टी लैंग्वेज टी बदला बदली हबो आपण जदी कॉपीटा अछि
Only खाली letter date.
कॉपीटा अछि कि से ऑर्डर टार देई परिबे I didn't hear
I have annexed.
Lord
Correction kari de de.
हाँ disposed of Mr. Vijay Kumar Behra dash English 1 for the petitioner, Mr. Biplav Mahanti for the sir debe gote kari yes. Your Lordship, can you say the last order? Yes. Management was required to file an affidavit. Did you obtain instruction? Could you?
Yes, my lord. In fact, let me clarify the position.
Yes.
On the last date, this submission was made on the basis of that the client.
Whatever instruction.
Yes,
but could you get up-to-date instruction?
Yes, today I have prepared an affidavit also.
Okay.
My learned friend is online. I can't serve him.
You must talk to Mrs. Patnaik. Let
me just submit, my lord.
Just that part. How many installment? I think that will be.
That my client is not pressing that prayer. I am filing that affidavit today. The reason being, he is not in a financial. He found it difficult to arrange that money. So that was.
No, you file it in the registry because it's paperless. It can take
you can take note of my statement.
Absolutely.
But one just prayer before my lord's.
Yes.
Lordship will kindly consider this petition bears three other players also with regard to challenging the demand. And that challenge of demand has come in several matters in the last vacation courts. And there are orders passed by this honorable court on that. If I can take liberty to show that to my lords. That the first prayer on which my statement with regard to deposit, I am not pressing. That prayer also I am not pressing.
Well taken, well taken.
And this order has been passed on last date. There is one more set of orders also, wherein this honorable court has been pleased to quash the demand in this honorable vacation court and remit the matter back to the superintendent. The learned counsel for the state was same.
No, the problem is that we can't vary the earlier order.
No, I am not asking to vary it, my lord. Since that was on my statement that order was passed, Lordship can record my statement that I am no more not in a position to pay in installment. That prayer I am not pressing.
Mr. Katke, can you अपना screen share कर ले?
That order is passed in my learned. My learned friend was also the lawyer in that case for the state.
So order टाकू काढून screen share करूँ so that
It's
Mr.
same,
Katke can see it.
identically placed, same situation.
Yes. But this, I mean, this aspect is text to be clear. वेबरू काढ़ी की स्क्रीन शेयर कर दियंतु अपन बाहर अच्छी की मिस्टर कट किया
No, I don't have the order.
सॉरी
I don't have the order.
नहीं आई अंडरस्टैंड एटा अपन बाहर कोटा से सी कोचो से
Mr. Katkia,
मिस्टर कटकिया वाज द एजी इन सिमिलर मैटर ऑर्डर हैज बीन पास्ड सेटा पचार
If my learned friend will tell me the number, then I can get
application
it.
number 13813 of 2024.
Right.
से शेयर करछन ठीक है जस्ट गिव देम 1 मिनट
Yes, he also-
I am also getting that.
अपन जदी स्क्रीन नीचे माने
Yes,
My-
because I am getting it.
brother is saying that if you can see yourself in the screen you
Or I am trying to get it on my screen.
ने अपन स्क्रीन में आनंतुनी ने वीसी रे आनंतुनी ए कॉन्फ्लिक्ट हो
Mr. Katkia,
ଆପଣଙ୍କର ଯଦି ଲ୍ୟାପଟପ୍ କି ସେପାରେଟ ଅଛି ସେପାରେଟ ସିଷ୍ଟମରେ ଯଦି ଦେଖିବେ ଦେଖନ୍ତୁ ଏଇ ସିଷ୍ଟମରେ ଆଉ ଇଣ୍ଟରଫିୟର କରନ୍ତୁ
ମୁଁ ନିଜେ ଦେଖୁଛି.
Mr. Katkia, you must be aware on 30th May 2024, during vacation, you were appearing in this case where Mr. Subir Palit's senior counsel was appearing.
My learned friend.
In the meantime you can take up the
Here, my lord, Soko's notice was issued under Annexure 5. Under Annexure 6, I have,
demand notice
yes, I have, under Annexure 6, I have given the reply. But reply is
You are
not being
still dabbling
considered.
with that conversion of beer to hard liquor and all that.
That-
Anyway,
that-
say order ta dekhe ki Nanda sir.
Action, vacation.
Liquor matters which cannot wait till
Lordship- No, Lordship, they are disposed
Liquor
of
bench-
with the direction that Superintendent Excise will decide my so-called reply.
No, I will not dispose of. Liquor matters which cannot wait after till listing. So please just wait. You press this judgment or order
Yes.
before the regular bench.
Lordship.
Maybe me and both of my brother will be sitting. That's another thing also.
Then similar matters are coming on 24th. Lordship,
I'll record your submission.
yes, ma'am.
I think it will be covered by, it is covered by this thing, this order. But you take instruction and you come back. You come back
Yes.
and we hope that you will not have a different view. We do not have to take
No,
a different
if
view.
the so-called notice has been considered or not, that is the
Yes. Arun Kumar Patra for this is item?
Item
Data matter.
Again, same. Both are same.
Mr. Arun Kumar Patra for the petitioner, Mr. Ekin on the AGA for the state.
Namaskar.
The petitioner is aggrieved. ମୁଁ ଆପଣଙ୍କୁ ଫାଷ୍ଟ ମ୍ୟାଟରଟା ଡାକୁଛି 13801 ଗୋଟେ ଲେଖନ୍ତୁ ସେକେଣ୍ଡଟା ହେଇଯିବ. The petitioner is aggrieved by the letter dated 9/5/2024 and 17/5/2024 issued by the opposite party number 1, state of Odisha, through the secretary to the department, secretary to the concerned department. As well as the demand notice, as well as the consequential demand notice dated 20/5/2024 into bracket annex 10 and praise for and six interference of this court to set aside the letters as well as the consequential demand notice. It is submitted by the learned counsel Subpara. It is submitted by the learned counsel for the petitioner that similar matter was taken up by the coordinate bench, coordinate vacation bench, vacation bench, and by order dated 35/2024, the matter was disposed of. Copy of the said order is produced, which is taken on record for reference. Copy of the orders has also been served on the learned AG, who shall obtain instruction by the in response to the submission of the learned counsel for the petitioner. List in the week commencing
24. Lots. 24.
एक सब जगह 24 रखन्तु
ताले सर
एक 7/2024 कना मार्च तो गलाडी
आगे
डिमांड ये तो गलाडी एटा कोन रिन्यूअल पई व्यस्त होचंती
ना
ठीक है रिन्यूअल पता ना विड्रॉ भी कर दे पारम सेटे कोन अछि
ना कौन कहियो डोंट नो
suppose he says that your client will not do this business
मैंने भी also
that way why you will bang your
that
head?
will apprehend also.
And that is the advantage of lawyers.
Yes.
So, it makes little difference for the learned counsel for the petitioner and the learned AG.
Yes.
So, 1/7/2024.
एक ही साथ both
24
items.
ରହିଥିଲେ better ହେଇଥାନ୍ତା କାହିଁକିନା 24 ରେ ଅନ୍ୟ matter ଗୁଡା ଆସିଛି so that
24 weekend
ଗୋଟେ
ଆସୁଛି
ଦିଟା ଆସିଛି ହଁ ଗୋଟେ ଦିଟା
କେତେ ତାରିଖ
24 ଦୁଇ commencing 24
week 17 24 କରିଦିଅନ୍ତୁ ଠିକ
Right.
ନାଇଁ it doesn't ମାନେ ସବୁଦିନ ଆମେ ଯଦି 24 କୁ ରଖିବା
ନାଇଁ ସେ batch
the list gets bloated for nothing ବ୍ୟାଚ୍ କେମିତି ଟ୍ୟାଗ ଅପ୍ ହେଇପାରିବନି ୱିଦାଉଟ୍ ଜୁଡିସିଆଲ ଅର୍ଡର ସେମାନେ ଟ୍ୟାଗ କରିପାରିବେନି
ମୁଁ
ଲିଷ୍ଟ ରେ ଆଡ୍ ହେଇପାରିବ
I'll mention it.
ଆପଣ ମେନସନ କରନ୍ତୁ
Published.
କିନ୍ତୁ ୱିକ୍ କମେନ୍ସିଂ 24 oblique moved by the
Book commencing
petition.
24th manner.
24th moved by the oblique moved by the
Ma'am.
petitioner ସେ କହୁଛନ୍ତି 24 ରେ ଆସିଲେ ସୁବିଧା ହବ ତାଙ୍କୁ
ठीक है.
ଆପଣଙ୍କ ମ୍ୟାଟର 24 ରେ ଆସୁଛି କହୁଛନ୍ତି
Right.
ତାହେଲେ କହିବେ ମେନସନ ମେମୋ ଫାଇଲ କରିବେ
Other matter annexure 9 ହବ demand notice
ସେଇଟା ଆପଣ
connected ହଁ
brief ଦେଖିଦେବେ ମୁଁ କରେକ୍ସନ କରିବି
ଆଜ୍ଞା ଠିକ ଅଛି published
14093 same order yes
May I please, my lords. This petitioner has taken loan in the year
South Indian-
2008. My lord.
ପଢିଛନ୍ତି ପଢିଲେ try to overcome South Indian Bank before approaching in these matters. South Indian Bank has reiterated Satyavati Tandon, referred to Anuwala, and really you just read it to what extent the Honorable Supreme Court has gone in saying that how and why the High Court is interfering.
Here, my lord, my humble prayer is, my lord, since
Yes.
the petitioner has submitted an application for one-time settlement,
Nothing,
my lord, that should be considered.
That
The
cannot be done.
lenient view.
One of my staff says that in his house today's the auspicious Vrata is not observed. So I was telling him that you file a writ. At least as an interim measure, it can be directed. He should have filed it earlier. But in this matter also, after South Indian Bank,
My lord.
so it's not possible. Either you adjourn or withdraw to move. The tribunal is functional. Tribunal is functional. Presiding officer. Last matter, the last day is last day actually at least two matters. I think they have withdrawn to move the tribunal.
My lord, let it be
Or you
taken
try
up-
to overcome South Indian Bank.
My lord, let it be taken up after vacation, my lord.
The Lord Counsel for the petitioner, after arguing for the sometime, arguing for sometimes seeks accommodation to obtain instruction and advance arguments. List in the week commencing
First week.
last week documents. ସବୁ ଜିନିଷ 1/7/2024.
Oh, plus. Oh,
You are not the assigned bench, so that you must understand. Oblique moved by the petitioner. ଆପଣ move କରନ୍ତୁ
oh, plus.
assigned bench. Yes, please. Next.
May I please, Lord?
Upon appearance, sir. This is item, you are Mr. Misra. Pramod Kumar Misra. Pramod Kumar Misra, state ପାଇଁ 5 ରେ Mr. L. Samantray.
ନାହିଁ ଆମର ରୋଲ କିଛି ବେଞ୍ଚ
ଆଚ୍ଛା କିନ୍ତୁ ପାର୍ଟି କରିଛନ୍ତି ଆପଣଙ୍କୁ ସେଇଟା ତ ଗୋଟେ ବଡ କଥା ନା। ଆପଣ ଇଏ ରେଭିନ୍ୟୁ ଆଣ୍ଡ ଡିଜାଷ୍ଟର ମ୍ୟାନେଜମେଣ୍ଟ ପାର୍ଟି ହେଇଛନ୍ତି। Mr. L. Samantray AGA for OP1. କପି ଦେଇନାହାନ୍ତି?
ଗୋଟିଏ
ଠିକ ଅଛି।
May I please, Lord?
Yes, please.
An application seeking direction to
Sudhir Kumar Mallik for the
yes,
petitioner, Mr. L. Samantray AGA for the state. Yes, Mr. Mallik.
an application seeking direction to the opposite party number 3 to settle the case land permanently in favor of a petitioner. Because the petitioner's father possessions in 1975, page number 15, my lord, note of a possession in name of father of the petitioner.
Yes, sir. Under which provision you are entitled to be settled?
OGLS Act.
How then it's not a division bench matter, I think.
Today the
And there is no reference to OGLS
Prayer.
as far as your pleadings are concerned.
yes, my lord.
What is the proceeding pending
Yes, my
in
lord.
OGLS
Yes,
against your
sir.
father?
And sir,
Your application, did you apply?
Yes.
Who has applied for under OGLS? You or your father?
myself, my lord.
Where is the application?
Annexure 3, my lord, page number 21.
Have you checked the OJLS Act? Just see the prayer. See the prayer what you have made at page 22.
Page number 17, my lord.
22 ଆପଣ annexure 3 କହୁଛନ୍ତି ନା ନା ଆଉ ଗୋଟେ କଣ
Annexure 2 series, my lord. Page number 17.
Sir, I asked you where is your application under OJLS Act? You are referring to annexure 3
Yes.
that ends at page 22.
Yes, my lord.
The C at page 22.
Yes, my lord.
Look at page 22. ନା ଆଉ ଗୋଟେ କଣ brief ଏପଟ ସେପଟ ହେଇଗଲା କି?
No, my lord.
କଣ prayer କଣ ଅଛି?
Settle the case in favor of a petitioner.
ମୁଁ କହେ ପାଉନି ସେଟା ମ୍ୟାଚ୍ କରୁନି ମୁଁ ଆଉ ପେଜ 22 ରେ ପ୍ରେୟାର ଲେଖା ହେଇଛି ଗୋଟେ କ୍ୟାପସନ ଅଛି ସପାରା ହେଇଛି 5 ଅଛି ତା ତଳେ ଗୋଟେ କ୍ୟାପସନ ଅଛି ପ୍ରେୟାର ତା ତଳେ କଣ ଲେଖା ହେଇଛି
To issue error.
We of the after fact and circumstance the case land owner may be kindly pleased to R pata in favor of
କେମିତି ପଟା ଇସୁ ହବ
note of a possession in remark column or in
ତା ପଟାରେ ତ ସେଟା ରହିବ ସେଇଟା ଆପଣ OJLS ରେ ଗୋଟେ ସ୍ପେସିଫିକ ଆପ୍ଲିକେସନ ଅଛି
application.
ଏଇ ଯୋଉ ଆପଣ ରିଡ୍ ଫର୍ମାଟ ରେ ଆପ୍ଲାଏ କରି ଆରଆର ପାଇଁ କହିଲେ ଆରଆର ତ କି
Page number 17 ରେ application ଟା ଅଛି.
ତାଙ୍କର ସେ କ୍ଷମତା ନାହିଁ ଆରଆର କୁ ଷ୍ଟେଟ ଆବେ ଇସୁ ମ୍ୟୁଟେସନ କେସ୍ ରେ
Page number 17 ରେ application ଟା my lord ଅଛି. 17. Annexure 2 series page number 17, my lord.
ତାହେଲେ କାହିଁ annexure 3 କହୁଥିଲେ
ତ ଦିଟା ସେ ବର୍ତ୍ତମାନ ପ୍ରୋଭିଜନାଲ ଯଦି ନୋଟ୍ ଅଫ ପଜେସନ ତାମାନେ ଅନଅଥରାଇଜ୍ ପଜେସନ
Obviously.
then there is a different proceeding gଭର୍ଣ୍ଣମେଣ୍ଟ ନୋଟିଫିକେସନ ଅନୁସାରେ whether it will be settled or not ସେ ସେଟଲମେଣ୍ଟ ରେ ଯିବ ସିଙ୍ଗଲ ବେଞ୍ଚ ରେ କିନ୍ତୁ ଯଦି OJLS ରେ କ୍ଲେମ କରୁଛନ୍ତି ଯେ ଆପ୍ଲିକେସନ ଇଜ ଆକ୍ସେପ୍ଟେଡ ତ ଇନକମ ଦେଖୁଛନ୍ତି 1 ଲାଖ ପର ତାହେଲେ ଏଇଥିରେ ତ କଟିଯିବ କ୍ରାଇଟେରିଆ
Questions was 7 number of questions.
ଆପଣ
John
କଣ ମାନେ
F.
you come back with better particulars or they will obtain instruction
Instruction.
okay note of illegal possession doesn't convert into a right of absolute ownership that you must realize
Yes, sir.
if it has been recorded on the last କେବେ ହେଇଥିଲା ଆପଣଙ୍କର ଏରିଆରେ ସର୍ଭେ କେବେ ହେଇଥିଲା ସର୍ଭେ ସେଟଲମେଣ୍ଟ ଆକ୍ଟ ରେ 82 23 ରେ ହେଇଥିବ ଏଟା କୋଉ ଜାଗା
ଜଗତପୁର my lord.
ଜଗତପୁର 82 23 ହେଇଥିବ ତାପରେ ଆଉ ହେଇନି ସୋ ଆପଣ 40 ବର୍ଷ ପରେ ନୋଟ୍ ଅଫ ପଜେସନ ଚେଞ୍ଜ ସିଏ କରିପାରିବେନି ତାଙ୍କର କ୍ଷମତା ନାହିଁ that is what I was telling you that ଆପଣ ଦେଇଛନ୍ତି Mr. AG has also said
Yes,
that
sir.
Mr. This is item 6, Mr. Even Mr. Malik, Sudhir Kumar Malik, Mr. S.K. Malik for the petitioner, Mr. L. Samantray AG for the state. The learned, the petitioner, learned, no, the petitioner 6 direction to the opposite party for settlement of certain government land in the premises that his father was in long occupation of the said land. The petitioner is entitled for settlement of such land and he has made application under form 1 through form 1, copy of which has been annexed as annexure 2 to the writ petition. The learned Sapara, the learned AG, appears on behalf of the opposite parties, all the opposite parties. All the opposite parties waives notice. He shall obtain instruction regarding present status of the proceeding initiated under the OJLS Act, if any, stop. To apprise this court. ସେତିକି ଜାଣନ୍ତୁ ଯଦି ହେଇଥିବ ତାହେଲେ ଆପଣ କହିପାରିବେ
Interim order, my lord.
ଆଜ୍ଞା
Status
ଷ୍ଟାଟସ୍ କୁ ଏଥିରେ ଦେଇ ହବନି
till next date.
ଆପଣ ତ କିଛି ଲେଖି ନାହାନ୍ତି ମୁଁ କୋଉଠି ଷ୍ଟାଟସ୍ କୁ how can you predict that you have been threatened under eviction predictive pathରେ predictive orders please don't request I must know what I am directing
Yes, sir.
केबे केबे आनिबे रखले हबो आईए रे करंतु इशू नोटिस एज above. So notice as above, the learned AG waives notice and shall obtain instruction. But IRA भी आनंद instruction.
ସେ ନୋଟ ଅଫ ପଜେସନ ଦେଖଉଛନ୍ତି 1975 ଆଉ ଏବିଟ କିଏ କରିବ ଯଦି ହେଇଥାନ୍ତା କେବେଠୁ ଏଭିକ୍ସନ
नहीं सीधा तो से आपण कौन प्रोसीडिंग रे आपण थ्रेटन नेची सेटा भी जणा पडुनी एंड इट हैज टू बी ओपीएली और तो
ମୋଷ୍ଟ ଲାଇକଲି ଓପିଏଲି କାରଣ
मोस्ट लाइकली ओपीएली नले आरोडा जोटा सिटी एरिया पे जोटा एप्लीकेबल टाउन एरिया पे सेटा ही पारे प्रिमाइसेस ऑफ अनऑथराइज्ड ऑक्युपेंट्स एक्ट
ଏଇଟା ମାନେ ରୁରାଲ ବୋଧେ ଲାଗୁଛି କାରଣ ସିଟ୍
टाउनशिप आसीओ म्युनिसिपल 14 म्युनिसिपालिटी
टाउनशिप जाउछि
टाउन कहले सेटा आ गोटे प्रोसीडिंग
ନେଇ ଆସିବୁ ଆମେ
आपण इंस्ट्रक्शन आनो केबे आनले काढी परिबे
ଛୁଟି ପରେ ସେ 24 ୱିକ୍
ठीक अछि वीक
କମିଟି
लिस्ट इन द वीक कमेंसिंग 24 6 2024 बिफोर द असाइन्ड बेंच
ତ ନଥିବ ଆଜ୍ଞା
public moved by the petitioner. Yes, please. Next.
May I please justify on BC matter.
Yes, please.
My lord, here I have challenged the demand notice for the shortfall MGQ. And in the similar matter, the coordinate bench of this honorable court has already issued notice, my lord. My associate is there with the copy.
Any one of your learned junior who can produce those.
Yes, he is there, my lord.
Apana number ta
Yes.
is there. What? गोटे मिस्टर त्रिपाठी को गोटे यू आर देयर गोटे कॉपी दियंतु आम गोटे दियंतु सेडे आपन देले कॉपी
नहीं देना दे
एटा ताकु दियंतु पाइले आ दिया मते दियंतु नो ना
Only the notice has been issued in this case, my lord.
ओ एटी सबुडा ताले फेरी दियंतु आपन एटा गोटे करेक्शन करि तांग दियंतु सेम ओडा
Next also similar, my lord.
गोटे सेकंड टिके रो गुरु फॉर द पिटिशनर मिस्टर विभू प्रसाद
Are you getting what the court master is saying? Pencil में लिखी की दियों सेटा पूरा हमारा करेक्शन करेगा कोई चाहूँगी
You request your learned junior to correct and submit that copy.
Yes, my lord. I mean,
Guru for the petitioner. So Vibhu Prasad Tripathi, AG, for the state, for the opposite parties, for the opposite parties. The petitioner inter alia challenges the demand notice number 1126 dated 25/2024 into bracket annexer 6 the writ petition issued by the Superintendent of Excise Berhampur comma OP4 issue notice and admission. The learned AG appears on behalf of opposite parties who have notice.
yes, my lord.
A list in the week commencing 8/7/2024.
My lord.
Public moved by the petitioner. Yes.
Next also similar. It also similar, my lord.
ଆପଣ କଣ ଏବେ renewal ଚାହୁଁଛନ୍ତି?
Renewal, renewal ପାଇଁ ପକେଇଛୁ ବୋଲି ଏଟା ଚାଲିଛି
ଆଚ୍ଛା ଆଉ renewal କଣ ହବ?
ଦେଖାଯାଉ we have already deposited the
Same appearance, Mr. Tripathi, you are there. Same appearance. Yes. Yes, next please. 9. Mr. Baral, your matter. 8 ହେଇଗଲା ଆଜ୍ଞା. At times you are fast also. Yes.
Here the materialist to land acquisition lordship.
Yes.
The grievance of the petition lordship, the annexer
ଆପଣ କୋଉ ଷ୍ଟେଜ ରେ ଆସିଲେ ହାଇକୋର୍ଟ କୁ କୋଉ ଷ୍ଟେଜ ରେ ଆସିଛନ୍ତି ଆକ୍ଟ ଅନୁସାରେ ମାନେ ନୋଟିସ ଷ୍ଟେଜ ରେ ହିୟରିଂ ଷ୍ଟେଜ ରେ ନା କଣ ବର୍ତ୍ତମାନ କଣ ସ୍ଟାଟସ
At the stage of releasing the money, Your Lordship.
ठीक ଅଛି
At that,
so you see you must understand that there has been an adjudication in somebody's favor
my lords.
so it will take notice I mean not only adjudication it has been the money has been directed to be paid yes
Adjudication, the matter, Your Lordship, only my prayer, Your Lordship, Annex 6, page 26, Your Lordship, to refer the matter under section 64 of the new act, Your Lordship, I have given a representation to the authorities, Your Lordship.
representation ର ସେଥିରେ scope ନାହିଁ you see ଆପଣ section 26 ଦେଖନ୍ତୁ ସେଥିରେ representation ର scope ନାହିଁ the reason is very simple because it's a fundamental right to property somebody is deprived of his or her property
My lord.
so that is an elaborate adjudication method where all objections are heard your case is that you are genuinely you are the actual beneficiary she is not the beneficiary
My lord.
but there has been adjudication so you take notice
Yes, Your Lordship.
so
but,
this court cannot issue a mandamus for consideration of a non-existent provision statutory mechanism after this stage there is no adjudication so this cannot court cannot create or arrange itself that let us adjudicate so take notice
Your prayer is not maintainable.
Sorry,
Your
my,
prayer is not maintainable.
my lord.
Your innocuous prayer is not maintainable.
to that you have to also respond
Even
Sir,
if
absolutely right
it will not fructify to your benefit. You can't reap any benefit out of it. Even if we direct for taking notice during this vacation.
we issue notice and admission କାରଣ ଆପଣ ଏଠି ବି stock ହେଇକି ରହିବ you are no and we are not going to interfere at this stage because somebody's valuable right will be deprived
Yes, Your Lord.
and there is a sufficient ଆପଣ statutory mechanism ରେ କୋଉଠି କଣ ଥିବ appeal କରିବେ that's another thing but in
Section 64, Your Lordship, it states that the
Mr. S.K. Baral for the petitioner Mrs. Suman Patnaik Mr. Patnaik AGA for the opposite parties 1, 2 and 3 the petitioner has made a prayer for the petitioners plural no petitioners have made a prayer for consideration of their representation para it is alleged that କୋଉ ପ୍ରୋସିଡିଂ ରେ ଆପଣଙ୍କର ମାନେ ଆପଣ ପାଇବା କଥା ପଇସା ପ୍ରୋସିଡିଂ ରେଫରେନ୍ସ କୋଉଠି ଦେଇଛନ୍ତି
proceeding reference, Your Lordship, page 23. That is
ଯାଇକି ଅଛି ମାନେ ପାରାରେ ଲେଖିବେ ନା ଆଉ ଆଭରମେଣ୍ଟ ଆଗ ଲେଖିବେ ତାପରେ ଆନେକ୍ସର କରିବେ ଆନେକ୍ସର 4 ଆୱାର୍ଡ କଣ ଲେଖିଲେ
yes, answer for it.
allege that pursuant to the land acquisition case 29 of 2023 a award has been passed by the appropriate authority in favor of the opposite party number
All, Your Lordship.
4
In favor of petitioners along with OP4.
ଆପଣ beneficiary
My lord.
ତାହେଲେ ତ ଆପଣ then why you are obstructing it apportionment ପାଇଁ ଆପଣ ସେଠି fight it out
OP4 is a stranger. She is no way connected with the property, Your Lordship.
Sir,
So
that-
she is not entitled to get any.
Arey, you may be very unhappy with OP4 receiving her share
My lord. No,
so if it is apportionment 3 plus 1 4
my lord.
so you will be getting 25% if she is eliminated you will be getting 33% difference of 8% then why you are scuttling it you fight it out for the 8% receive without prejudice you see we are not here again to going to that side and I mean briefing you telling you what is the exact nuance legal nuances of such a thing
No,
I don't think এটা খালি কোন কইলে to frustrate the entire thing. সে পাইবেনি কি আমি পাইবনো. But you must realize that you are being deprived of the 25%.
she's a stranger, Your Lordship.
Sir, I'm not here to decide, or we are not here to decide whether who is stranger or not.
My lord.
Your difficulty is that even if she is a stranger, she is being awarded about 25%. Let it be. But you are, but
While the notice is Your Lordship annex.
anyway, ଆପଣ ବୁଝିବେନି ଛାଡ଼ନ୍ତୁ କ'ଣ ଲେଖିଲେ? Opposite party number 4, it is alleged that the opposite party is a stranger. Opposite party number 4 is a stranger. Court, single court रखियो stranger टा. The issue notice and admission, learned AGA, appears waives notice and shall obtain instruction from the opposite parties 1, 2, and 3. Issue notice to OP4 by registered post or speech post with AD. Requisites within 5 working days. List କୋଉ ୱିକରେ ଚାହୁଁଛନ୍ତି ମୁଭ୍ କରିବେ?
24 Lordship.
ଆଜ୍ଞା
24 June.
List in the week commencing 8 July. ଏଇଟା actually wait କରିବା କଥା after vacation. This is not a matter which cannot wait. ଆପଣ ଯୋଉ ପଇସା ପାଇବେ ତାକୁ ଅଟକେଇବାକୁ ଚେଷ୍ଟା କରୁଛନ୍ତି, ଏଥିରେ ଇଣ୍ଟରିମ୍ ଅର୍ଡର କ'ଣ ହେଇପାରିବ?
ନାଇଁ ରିଲିଜ କରିନେଲେ ସିଏ ବି ନେଇଯିବେ ପଇସା.
ସେଇଟା ତ ମୁଁ 25% କହିଲି, ଭେରି କ୍ଲିୟରଲି ବୁଝେଇଲି. ଆପଣ ପାଇବେ 33, ପାଇବେ 8% ଡିଫରେନ୍ସ. ଆଉ କ'ଣ କହିବି? ସେଇଆ ତ କହୁଛି ଆପଣଙ୍କୁ, ଆପଣ 25% ପାଇକି 8% ପାଇଁ ଫାଇଟ୍ କରିଥାନ୍ତେ ସେଠି ଆପର୍ସନମେଣ୍ଟରେ. ସେ ତ ଆପଣ ଅବଜେକ୍ସନ ଦେଇଥିଲେ, ସେ ରେଫର କରିଦେବେ. That we do not know also.
ସେ ରେଫର କରୁନାହାନ୍ତି ବୋଲି ଆମେ ଆସିଛୁ. Only that there is.
ସେ ସେଟା ହୁଏ ଆଜ୍ଞା, ସେ typical fight between for in the family for pension and all that, somebody claiming to be the actual wife and somebody coming to be the not the wife. Yes, next.
IA ଦେଲା ସମୟ
IA କରନ୍ତୁନି.
IA notice.
IA କଲେ ନାଇଁ, notice କରିବେନି.
Unless only
it is self defeating IA.
No,
ଆପଣ ରିଟ୍ରେ ନୋଟିସ୍ ନିଅନ୍ତୁ, ଆପିୟର କଲେ ପ୍ଲେସ୍ କରିବେ. ଆଇରେ
ନୋଟିସ୍ ଟା ଖାଲି ଯାଇଥାଉ, ଷ୍ଟେ ମାଗୁନି, ଖାଲି ନୋଟିସ୍ ଟା
ନୋଟିସ୍ ଆଇରେ ନୋଟିସ୍ କରିବେନି.
ଅଦରୱାଇଜ ହେଲା ସେ ତ ପିଟିସନ ସଫର ହେଲା ସେ
ପିଟିସନ 8% ପାଇଁ ଫାଇଟ୍ କରିବେ, ସଫର କରିବେନି. ପିଟିସନଙ୍କ ଏହା ଲାଭ ହବ, ଆଇରେ ନୋଟିସ୍ କଲେ କିଛି ପାଇବେନି. ଟୋଟାଲ କେତେ? 66 lakhs,
91 lakhs,
ଆହୁରି ଅଧିକା.
ଆଜ୍ଞା
25 ଲକ୍ଷ ଟଙ୍କା ପାଇବେ ବର୍ତ୍ତମାନ. ନୋଟିସ୍ ନ କଲେ, ନୋଟିସ୍ କଲେ କିଛି ପାଇବେନି.
98 lakhs.
98 lakhs.
ହଁ, ତ ଲକ୍ଷ ମାନେ କୋଟିଏ ଟଙ୍କା ଆଉ 25 ଲକ୍ଷ ଟଙ୍କା ପର ହେଡ୍ ଆଉ approximately 25 lakhs. Yes. Yes,
may I please, my lord? The subject matter of challenge in this writ petition
similar to
similar matters of matters.
ଗୋଟେ order.
I've made the necessary.
Why don't you correct it?
I've made the necessary correction and actually one series and the date.
ଯାହା ବି କରିଦେବେ କରିଦିଅନ୍ତୁ ଏଗୁଡା ରଖିବେ ନା ଫେରେ ଏଗୁଡାକ ଫେରେଇ ଦିଅନ୍ତୁ
Confuses.
ପ୍ରୋବ୍ଲେମ ହବ
And I've made the necessary correction.
ସେଇଟା ଦିଅନ୍ତୁ
That's
କରେକ୍ଟେଡ ଏଇଟା ଦିଅନ୍ତୁ
Again, corrected it.
ନାଇଁ
Paragraph 3 ଟା
ସେ ଆରଟାରେ ଆଉ ଗୋଟେ ଅର୍ଡର ଅଛି
issue notice ଯୋଉଟା ହଉଛି
ଯୋଉଟା ଜଷ୍ଟିସ
adequate.
ଯୋଉଟା ଅନରେବଲ ଚିଫ ଜଷ୍ଟିସଙ୍କର ଗୋଟେ ଟିକେ 2 ପେଜ ଅର୍ଡର ଅଛି ସେଟା କରିକି ଦିଅନ୍ତୁ
Again, ସେଟା କରିକି ମୁଁ ଦେଇଦଉଛି.
ହଁ ଏଇଟା ଫେରେଇ ଦିଅନ୍ତୁ
Oblations.
appearance memo filed by the learned senior counsel on behalf of the senior counsel not filed by behalf of the senior counsel shall be taken on record scan copy be updated
Oblations.
ଆଉ କିଛି ସେମିତି ମ୍ୟାଟର ଅଛି କି ନାଇଁ yes
In short, the problem here is the petitioner is a licensee, was selected in lottery, granted license. Before grant of license, clarification was asked from the state that he is going to open it in the municipality allotted sum. Please clarify us. Executive officer wanted clarification. Excise authority, after receiving that letter, granted me license. I operated it. While I was operating the license, municipality cancelled my allotment.
allotment of the land or the shop room
Sir,
allotment of the shop room
shop room. As a consequence, if a lordship sees only page 28, I'm sorry, not the closure order, that is at page 34. Just see page 34. Page 34 of my brief.
yes
You got it, my lord?
yes Annexure 7
First line. In exercise of power conferred under section 26. Lordship got it.
yes please
So this is in exercise of power under section 26, collector closes my shop. I have never closed it. Collector under section 26 directed me to close this shop.
yes so this is a closure period demand
This is a closure period waiver.
demand where is the demand
Demand is annexure 2. This is only
Yes.
during that closure period. Now, I asked that is waive it because closure is on account of your order. I reopened it when you allowed me to reopen. Now, I cited a number of judgments. They are governing the field. They say, your lordship sees, kindly see one paragraph from the impugned order, page 17. Just see page 17, the penultimate paragraph. Just see, man.
yes
How total non-application of mind here. Kindly see the penultimate. Whereas the collector Khurda had later dated stated that representative petition dated 28/3/24 for waiver of MGQ for the closure period merits no consideration. As the shop was not closed under section 26, when the closure order itself is under section 26. Right. Let's see, got it, well. Right. So I say this is a clear non-application of mind. I mean, now consequent upon this, you have issued me a demand notice.
so what would be the demand if the opening period is taken into account
Right, my lord.
suppose the total demand is 100
Correct.
for the closure period it is 20
Correct, my
for the
lord.
opening period it is 80
Right, my lord.
so deposit 80 take a stay for 20
I don't mind, my lord. But
so please come with that fact
that is there, my lord. The whole demand is only during there is no demand thereafter. No?
that I got
Yes, my lord.
I'm just responding to the submission
Right, my lord. I'm grateful.
for a section 26 closure period
Yes.
you are perhaps entitled for
Pass that order. Kindly pass that order.
that proportionate demand ଜାଣିବା କେମିତିଆ
So whatever they will tell me, I'll pay that. After this closure period, whatever they will say, I'll pay that.
so this order will be made conditional
Conditional.
is Mr. P.K. Ratha, Senior Counsel, instructed by Sai Brata Ratha for the petitioner. Yes, Mrs. Patnaik,
Yes, your lordship. That would be fair.
for the timing, let there be stay of that portion.
Yes, your lordship.
But
It has to be recalculated, your lordship.
yeah, but the difficulty is that, I mean, the petitioner doesn't know, maybe obviously.
Let them say whatever comes.
Yes. No, if you would have suggested any amount, then it could have been, I mean, they could have been asked, but you do not know basically. Yes. Of the AG लिखिए, say Mrs. S. Patnaik. The petitioner is agreed by the demand notice dated 18/5/2024 issued by the Superintendent of Excise, Khurda,
Khurda,
OP number 4,
OP number 4.
demanding an amount which according to the petitioner relates to
Closure
the
period.
period of closure that was directed by the order dated 26/4/2021.
That was directed by order 8/4/2022.
Page
Page 34.
Page 34.
Right.
Para one the selection 8/4/22 to 1/12/2022.
Correct.
So right, pursuant to 8/4/2022 into bracket annexure 7 issued by the said opposite party.
By the collector.
The learned senior counsel submits that the period of closure was from
8/4/2022
8/4/2022 till
1st of December 2022.
1st of December 2022. It is further submitted by the learned senior counsel that the order rejecting the petitioner's prayer for waiver of demand for the period of closure was rejected by
By the opposite party number 1.
by order dated
13th of May 2024.
13th of May 2022 24 into bracket annexure
1.
annexure bracket closed. The learned senior counsel refers to the said refers to the annexure 1 to argue that though the shop was closed under section 26 of the Odisha Excise Act 2008, the fact was not taken into account by the authority while passing the order. Authority into bracket OP number oblique dash OP number 1 while passing the order dated 13 May 2024. Issue notice. The learned AG appears on behalf of the opposite parties, waives notice. IA. Issue notice as above. Learned AG appears and waives notice. In view of the fact that the shop was closed under section 26 of the Odisha Excise Act, 2008 for a period as indicated in page 34 for a period as indicated above. Copy paste karantu by karantu. This code directs that the demand shall be the demand notice, the demand of amount notice, no, that the demand of amount as contained in
Annexure 2.
Annexure 2 shall be recalculated by separating the closure period from the period. The it upon IMFL offsub. The IMFL offsub was kept open. The petitioner shall be asked to deposit the amount corresponding to the period of opening of the IMFL offsub and excluding the period of closure. Such recalculations be made and the petitioner be noticed within 3 weeks. Mrs. Patnaik, now 4 weeks.
4 weeks.
Within 4 weeks, the petitioner shall be given further 2 weeks time to deposit the amount.
If I am subject to
Within 4 weeks from the date of communication of the order.
one just minute,
Please.
Probably your lordship said that the petitioner shall be asked to pay the amount during closure and open. But that
No.
kindly
No, I'll correct it. No, I'll correct it. That is the real challenge. After this is over, that is the real challenge. No problem.
I'm so grateful.
Because rest it will be there in the memory.
Right.
The other part is that since the context is already dictated,
Right.
it will not be forgotten.
That happens.
Further 2 weeks time to pay the amount demanded for the
During open.
period of opening of the IMFL offsub.
Right.
urgent expedite copy as per rules. Yes. Date যদি করিবে তাহলে একটা 4-2-6 6 weeks 8 weeks পরে ডেট করতো।
Yes. Subject to deposit of the amount, petitioners will be allowed to current, I mean.
আচ্ছা লাস্ট লাইন যেটা লিখলেন যেটা urgent expedite কথা পূর্ব লিখবে till such decision is taken and the petitioner is till such recalculation is made.
Yes.
And the petitioner is directed to pay the amount and the petitioner is given 2 weeks of time. No coercive action shall be taken against the petitioner pursuant to the demand notice
Annexure 1.
into bracket annexure 1.
2.
Annexure 2. Correct. List in the week commencing 22/7/2024. Public moved by the petitioner.
Grateful.
Yes, please.
May I please look? Your mind of my vested right have been taken, my lord, by changing the condition of service in the new rule. I have annexed the old rule, my lord.
You take notice. You take notice.
Yes.
आइए कौन हम कोट करछंदी कि
I consider the new rule consider career for only one I am only one person available for consideration, my lord.
केबे अछेडा अछि
Say I say कोठी date is a
तनु सेडा let them respond because the order will be then neither here nor there.
ସେ ତ ଗୋଟେ ଲୋକ ଅଛନ୍ତି।
परंतु why I am saying Mr. Malik, they may consider you also.
ସେ consider करे ଗୋଟେ ମଝିରେ ଗୋଟେ extra
In this kind of a dicey situation, if
Yes,
you
sir.
instigate something,
let me take note.
they simply say that court re case pending अछि आमे किछ करिवे।
Let them take note. Let me take
Mr.
note.
Siddheshwar Malik for the petitioner. Mr. Biplab Kumar Mahanti, AGA for the state. The petitioner submits that it is submitted by the learned counsel for the petitioner that the petitioner has not been considered for promotion to the post of senior lecturer.
Automobile engineering.
Automobile engineering in the cadre of Odisha Technical Education Service.
Yes.
Subject सुनो ठीक है कौन तो Odisha Technical आप लिखते हैं Technical Education.
Odisha Government Polytechnic Teachers.
Now it is Odisha Government Polytechnic Engineering Service.
Service टा कौन?
Service now. Earlier it was Odisha
Rule टा लिखते हैं service टा लिखना है अपने rule टा लिखिए
Odisha Government Polytechnic Service method of
सेटा काहे की रेफर करछि बुझ पार नांती आपण कहउचंती ओल्ड रूल थिला नुवा रूल रे आपण एलिमिनेट करले पर्पसफुली आई एम अवॉइडिंग टू रेफर टू द रूल बट सर्विस जो कैडर टा मते तो कहिबे मेडिकल एजुकेशन सर्विस टेक्निकल एजुकेशन सर्विस नाउ एजुकेशन सर्विस ठीक है छाड़ दियो सर्विस
पॉलिटेक्निक टीचर्स सर्विस में
सिम्पली किछि सर्विस नहीं आपण रूल टा रेफर करचंती यू आर सेइंग दैट 24 रूल्स रे आपण डिप्राइव्ड हे जिवे आपण ओल्ड रूल रे 85 रूल रे आपण एलिजिबल सो आई विल नॉट ऐड माने fuel to fire so da mu seda likhile they will interpret and
Odisha Technical Education and Training Service.
lecturer single lecturer
Odisha Technical Education
yes
training service quote unquote कर दियो single quote कर दियो
Odisha Technical Education and Training
Service issue notice the learned AGA appears and waives notice on behalf of the opposite parties सब जाक अपन देखे कंपिटिटर ना देखुछन
नहीं
on behalf of the opposite parties the learned AGA shall obtain instruction regarding the shall obtain instruction and file counter if so advised by the next state in view of the limited grievance raised by the petitioner that he may be considered for promotion being otherwise eligible. List in the week commencing Malik
short date 24th or next week
एक साथ 24 से आनी परले सिना आपण बर्तन कंसिडरेशन हम प्रमोशन पे आपण डीपीसी हम भाउचंती
डीपीसी नुआ आर्गुमेंट first July कर दूँ पूरा.
8 जुलाई रहो.
Yes.
And don't, unless you are sure that you will be not considered, please don't. I am not very sure it is a sound approach.
No, I will not be considered.
Either way.
No, I will not be considered because senior lecturer.
I said I shouldn't. How the candidate will know?
नहीं नहीं,
There is no DPC criteria. आप criteria आनिଥାନ୍ତେ.
ନୂଆ rule ରେ ଆଉ ଗୋଟେ post ମଝିରେ ଭର୍ତ୍ତି କରିଦେଇଛନ୍ତି.
ନୂଆ rule ରେ ଆପଣ earlier rule apply କରିକି ଜଣେ reject ହେଇଯିବ, it is most unlikely. There have been several ମାନେ
Yes,
this is a very old service, old cadre.
I am referring a constitution bench judgment of.
ଆପଣଙ୍କର old cadre. This is a very old cadre. ବୋସ୍ କେବେଠୁ ହେଲାଣି? ବୋଧେ REC ପୂର୍ବରୁ ବୋସ୍ ହେଲାଣି. This is a very old cadre. So
Let them take notice.
yes, yes. Issue notice and admission कर दियो. Admit को लिखी ना contact. Had issue notice and admission.
Yes.
Indicating that the matter is likely to be disposed of at the stage of admission.
Yes.
The appearance डाकी दीजिए. Yes. Yes, please.
Yes, Lord. The at the instance of the office,
You are not Mr. Joy Singh Behra?
yes, SS Jana.
Mr. S.S. Jena ଅଛି party ଅଛି. Sorry, na ଅଛି. Mr. S.S. Jena for the petitioner.
Your Lordship,
The IA file କଲେ conversion ପାଇଁ?
ଆଜ୍ଞା ସେଟା ଖାଲି ଅଫିସ ର ଗୋଟେ
252 ନା କେତେ
ସାର୍ ଏଇଟା ଆକ୍ଚୁଆଲି ମାଟରଟା ମେଣ୍ଟେନେବୁଲ ଅଫିସିଆଲି କହିଲେ ବୋଲି ମୁଁ ଏଇଟା ଫାଇଲ କଲି ଅଫିସ ଏମିରେ ଇନସିଷ୍ଟ କଲେ
ନାଇଁ ତାହେଲେ ଚେକ୍ କରନ୍ତୁ.
ନାଇଁ ସାର୍ ସେ କହିଛନ୍ତି ଗୋଟେ ନେଇଛି
Stamp reporting is not usually subject to judicial scrutiny.
Sir, what is the law itself contemplates any order or judgment, sir, but not being interlocutory order.
It is interlocutory order.
Sir, ମୁଁ କହିଦଉଛି ସେ ଏଇଟା interlocutory nature ଆସିବ କି ନାହିଁ ଏ ଯୋଉ 8-5 order impugn order ଟା that is only criteria.
ସେଟା ଆପଣ ଫାଇଲ କଲା ପରେ ସେଠିରେ ଆର୍ଗୁମେଣ୍ଟ ହବନି?
ଆଜ୍ଞା
କଣ ଆଜ୍ଞା କହୁଛନ୍ତି?
ନାଇଁ ସେଟା
nomenclature is subject to judicial review. ଆପଣ WQC ଫାଇଲ କଲେ ବି WQC ଶୁଣନ୍ତୁ, you are not remedialess. Instead of a matter, you will be filing a WQC. But the statute is very clear. It is not to be interlocutory order.
Not being.
So your interpretation is that it is not interlocutory order. So say argument you can make it.
Again, whether it is coming under interlocutory or final firm order.
Mr. Jena, you are not following. If you are not sure what is the
examination,
if you are not sure, if you are not, we are not taking upon the merit. As far as interference is concerned, we can interfere if it is filed in the proper format. If there is a stamp reporting that it should be writ petition, we do not have a jurisdiction also. That you must realize.
That being linger the matter because
first point. Second point, suppose you say that it is not an interlocutory order. How the court will decide now before the matter being filed?
In pursuant to the Supreme Court order, the 1970, 70, 80 or 80 ଟିକେ ମନେ ପଡୁନି କିନ୍ତୁ ରିକଭରି ଅଛି ଅର୍ଡରଟା ଅଛି ସେଥିରେ କହିଲେ ହୁଇଚ
ଆପଣ ଯୋଉ ଇଣ୍ଟେଲିକ୍ଚୁଆଲ ଅର୍ଡର ହେଲା ଫ୍ୟାମିଲି କୋର୍ଟ ଆକ୍ଟ ରେ କେବେ ହେଲା କୋଉ ମସିହାରେ?
ସେଇଟା ହଉଛି 85 ଲାଷ୍ଟ ମନ୍ଥ 8th of last month 85 2000
ଇଣ୍ଟେଲିକ୍ଚୁଆଲ ଅର୍ଡର ଆପଣ ଗୋଟେ ରେଫର କରୁଛନ୍ତି ଫ୍ୟାମିଲି କୋର୍ଟ ଆକ୍ଟ ରେଫର କରୁଛନ୍ତି ତ?
ହଁ ଆଜ୍ଞା 19 subsection 1 save as authorized save as provided.
ଆପଣ କୋଉ ଅର୍ଡରଟା କହୁଛନ୍ତି ଇଣ୍ଟେଲିକ୍ଚୁଆଲ ନୁହଁ ବୋଲି?
85 2020
କୋଉ ପେଜରେ ଅଛି?
annexure 1
ପେଜ ପଚାରୁଛି annexure 1
sir page number 19 that page annexure 1 page number 19. Order dated 12/2/2024.
12/2/23
12/2
ବର୍ଷେ 4 ମାସ ପରେ ଚ୍ୟାଲେଞ୍ଜ କରୁଛନ୍ତି?
ନାଇଁ 12/2/2024
12/2/24
ଆଜ୍ଞା।
ଆଚ୍ଛା 23 କହୁଛନ୍ତି? 23 ଟା କଣ ଇଂଲିଶ ରେ 24? ଠିକ ଅଛି।
ନାଇଁ sir, I'm sorry sir, order dated first page number 12, please kindly see page number 12. Order dated 85/2024
8/5/24
ଆଜ୍ଞା। This order arises out of petition.
ଆପଣ ପେଜ 26 ରେ ଲାଷ୍ଟ ଅର୍ଡର ହଉଛି 29/4/24 ଆପଣ ତାକୁ କାଇଁ ତଳ ଉପର କରି ରଖିଛନ୍ତି? annexure 2 ରେ ଆପଣଙ୍କର ରହିଲା ଅର୍ଡର ଡେଟେଡ 29/4/24 annexure 1 ରେ ରହିଲା 8/5/24
ଆଜ୍ଞା।
ଆପଣ ତାକୁ ସିରିଆ ଟିମ୍ ରଖିବେନି? Sir, ନାଇଁ ଦୁଇରେ ସବୁ ଯାକ ଅଲ୍ ଟୋଟାଲ ଅର୍ଡର ଫାଇଲ ହେଇଛି ୱାନ୍ ମଧ୍ୟ ଆପଣ 8524 ର ଫାର୍ଷ୍ଟ ଲାଇନ ଟା ପଢିଲେ ରିକଲ କଣ ଫାଇଲ କରିଥିଲେ ରିକଲ ଫାଇଲ ହେଇଥିଲା ସେ ଅର୍ଡରଟା ଯୋଉ 22/2 ଯୋଉ ଅର୍ଡରଟା ହେଇଥିଲା ସାର୍ ହଁ ପେମେଣ୍ଟ ଅଫ ଏରିୟର ମେଣ୍ଟେନାନ୍ସ ନାଇଁ ନାଇଁ ସାର୍ ସେ କଣ ହେଇଛି ଏଥିରେ ଆରେ ସବୁ କଥାରେ ଆପଣ କଣ ହେଇଛି କେତେ କଣ ହେଇଛି ଏଥିରେ ଆପଣ ଡେଟ୍ ଭୁଲ ଭାଲ ନାଇଁ ସାର୍ ଆପଣ ପ୍ଲିଜ ଟ୍ରାଏ ଟୁ ଆନ୍ସର ଦ କୋର୍ଟ when the court is interacting it is in your favor at least you know what the court is thinking what you wanted recall which was not granted or granted in the order dated 8524 which order was to be recalled order dated please can order page number 19 order dated 12/2/2024 for what directing what in which ବ୍ୟସ୍ତ ହୁଅନ୍ତୁନି ଆପଣ concentrate ଆପଣ what was the direction you wanted for recall sir order dated 6/3/24 order ଟାକୁ ଚାର ଥର କୁହନ୍ତୁନି date page annexure କୁହନ୍ତୁନି I am asking you what was the order that has to be complied and you wanted recall of that order what was the direction was made to the petitioner as to pay expat maintenance so I said in the beginning after that you have been arguing so how can it be a final order it's interim order it's interim maintenance interim order in the pending CP has been disposed of CP has posted for argument not disposed of not even disposed of posted either if it is final order you show that
Mr. Jana the annexure 1 last line that application has not yet been disposed of it is put up for further orders that means this order is interlocutory in nature.
Again.
So once it is interlocutory in nature, the Family Courts Act prohibits this petition.
Sir, it is
this petition is incomplete itself.
No, sir. In its present format, I don't know why you are laboring on that point. Whether it will be a WPC, on the face of it, it cannot be a matter. It cannot be a matter. ठीक ଅଛି ଖାଲି ଠିକ ଅଛି ଆପଣ କେତେ ସମୟ ନେଲେ କହିଲେ others are waiting and both my brother and we are writing a long list for the day ନାଇଁ ସାର୍ ଫାଇନାଲ ଇମ୍ପ୍ଲିମେଣ୍ଟେସନ ଟେ କହିବାକୁ ଚାହୁଁଥିଲି ସେ ଉପରେ କହିଲେଣି ତ ଆପଣ ନା ସେ କହୁଛି ଆପଣ ତ ମୁଁ କହୁଛି ଆପଣ I am somehow I don't know how I am ମାନେ more responsive than you alright ଯଦି if you court disinterested how can I say alright I am not ଶୁଣନ୍ତୁ ମୁଁ ଷ୍ଟାମ୍ପ ରିପୋର୍ଟର ହେଇପାରିବିନି ଆପଣଙ୍କ କନଫ୍ୟୁଜନ ଅଛି ଆପଣ ମତେ ଷ୍ଟାମ୍ପ ରିପୋର୍ଟର ଭାବୁଛନ୍ତି then what you are arguing upon jodi kohiba I can reject your prayer dismiss your petition do you want that no difficulty you challenge that you want dismissal of your petition no then why you are I don't understand I can really you see the whole deliberation is that so that it is in your favor that you do the needful if you want that it will not be converted to a writ petition it will be dismissed I can't rewrite the statute and become a stamp reporter and say that this is not interlocutory order and let it be a matter and I'll take it up. Because matter will confer jurisdiction on me. Writ petition, it's a single bench matter. On us rather. On us. Maybe in the single bench I'll be sitting. That's another thing. So don't do this. Maybe allowed to petition. You simply go by the rule and you argue, suppose you argue that this is a final order, whatever, you can still it is open for you and it is not at all a final order. And don't mix up these pages. No, sorry. Whenever you are making an annexure, this is advice, this is nothing to do with the merit. Start with the first order, end with the last order. But you are starting with the last order. It becomes so much difficult. Last final judgment order judgment it cannot be and you have heard my learned brother that it is still in that order also it refers that it will be with office note put up this and so and for the further hearing orders you do mean to say that you will not pay interim maintenance no sir that's a different thing no sir interim maintenance order sir these are all CP sir these are all subterfuge of not paying maintenance coming here going there and getting stay that is not point then why you pay the maintenance? No, sir. I proceed with the order. I am not liable to pay, sir. Maintenance order. Sir, you find out a husband who says that is liable to pay or wife. Have you realized you are maybe you are entitled to receive also, sir? You are for the husband or the wife? Husband. Are you not entitled to receive maintenance? Yes, sir. Then don't waste time, Mr. Jana. Don't waste time. Your petition deserves to be dismissed after this kind of, because suppose I record all these discussions with you, I have to dismiss your petition.
Conversion may be allowed. Conversion may be allowed.
That you have to remove the defect in the registry. Not here.
Again, conversion allowed. And
आइए कितने नंबर पचार आप फास्ट पचार कितने नंबर आइए तापर आपण आरंभ कले डिस्कोर्स
IA 252.
IA 252 of 2024
25.
the IA has been filed by the petitioner referring to the office note put up by the registry giving the details of the SR dated 30/5/2024. 30th May 2024, the staff reporter has indicated that the petition has to be registered as WPC. The prior bid in the IA is allowed. The petition shall be converted to WPC. The cost title and other necessary changes be carried out by the Lorded Counsel for the petitioner. By how much time?
Maybe sir eta posting करछंदी 22 तारिख को जजमेंट पाई एटा को नेक्स्ट 11th सर रखा जाओ 11th
11th vacation bench re?
हां सर
No, no.
Matter urgent sir.
Sir, the High Court judges are not supposed to take up every matter. They lack jurisdiction. I cannot direct more power nahi. Ask court ro power अछि मु असाइन कर दे बेगर कर देबे बोली ना कोन.
और रिअपॉइंटेड सर
कोन लिखले?
रिअपॉइंटेड.
आपण केते टाइम रिमूव करे केते टाइम ले मते कोंतु सेटा से
रिमूव खाली सर कोर्स ऑफ डे ना खाली
within 3 working days after conversion of the petition it shall be listed when moved by the petitioner. आपण भाई ऑथर रिमूव करन द एप्रोप्रिएट बेंच रे हैला
सर रिअपॉइंटेड
मोर आज्ञा मु से बेंच रे नाही मो असाइनमेंट हेले मु कर देबी ना कोन समस्त करिबी. Yes. Mr. S.S. Jena for the petition.
Item 14, my lord. My lord, senior Mr. Patnaik is out of station.
Your name, sir?
My name is J.R. Behra, Jyoti Ranjan Behra.
Mr. J.R. Behra, J.R. Behra for the petitioner. Mr. Tanmay Misra. Opposite party जा लिखिए for caveat आपन party हेचंती नाही ना
Opposite party 2 to 5.
caveat करथिले असी पार्टी करछंती ना कर देछन अच्छा
Copy भी दे दीजिए.
अच्छा Mr. Tanmay Misra for the caveator oblique opposite parties 2 to 5. The Lorded Counsel for the petitioner seeks accommodation on behalf of the arguing counsel due to personal difficulty. List when moved by the petitioner. Since the caveators oblique opposite parties have already been made have already been arrayed as opposite parties and copy has been served, the caveat stands discharged. Adequate position to copy. Have instruction?
Instruction I have taken.
Instruction भी आसी है ठीक है. Cabinet will आती हो. Yes, Mr. Kashyap.
My lord, for opposite party number 1 we have
41 by Satya Sindhu Kashyap, CGC along with DSJ.
My lord.
Along with the DSJ, Mr. Paddy. How can you know Chandigi?
No, my lord.
Notices to
For 6 and 7 notices to go.
अच्छा Behra engineering works
After admission.
आपण admission argument आज करू नांती पर adjournment मागुछन्ते अच्छा ठीक अछि list when moved by the petitioner move करिवे 20 Kashyap he is not he is simply seeking adjournment.
My lord.
नो ऑपरेशन नोट कर देबे आपण ये आपण 2 to 5 6 7
नहीं सर
I will ठीक अछि और रहला किसी पास थैंक यू
Petitioner is the proprietor of the travel agency. And
So, petitioner is the proprietor
of the travel agency.
Travel agency. Travel agency. Okay.
Victim's vehicle lordship engaged in the BSNL office lordship. And there is and page 13 lordship.
Allegation kete tangara?
Lordship 96,780.
Setiki?
96,780. Let them pay out. Mediation payment.
It's a recovery proceeding. You have to look at that Supreme Court decision where Supreme Court says this cannot be a recovery proceeding.
That's true, ma'am.
If you are directing, then he has to deposit it.
Yes, ma'am.
Whatever the law and trial court will. Acha, you noting what I can't say the Muto Kojuchi, I think it's not. Honorable Court's order dated 28/5/24. It's the nine other. ଆପଣଙ୍କର କିଛି ଅଛି
ଲେଜିବୁଲ କପି ଦେଇନାହାନ୍ତି
ନାଇଁ 28/5/24 ଅର୍ଡର
ହଁ એટલે આમાં જે ଲେଖା ହେଇଛି to supply the legible copy of the FIR matter.
Receive file receipt no counter receipt.
ଫାଇଲ କରିଛନ୍ତି
Receive in the registry of file yesterday receipt.
କୋଉ ଗତକାଲି
Receipt. It has been not come.
ଆପଣ କାଲି ଫାଇଲ କଲେ କେମିତି ଆସିବ ଆଜ୍ଞା ସେଟା so everything is scanned and everything, so how can it be done?
Receipt.
That 1cc case was converted to FIR, my lord.
I can modify that order. Should I add on to court? Mr. Das, when, at what time you filed counter?
Receipt 12 p.m. receipt.
बंद है पर
possible receipt I will
can I modify earlier order by the coordinate bench?
Receipt passover I will file the hard copy in the 2 p.m. receipt.
Passover 2 p.m. केमते हो?
I will
अपन पर भी किसी नहीं.
I file the copy.
काको उठे पठो नहीं WhatsApp रे यदि भलो कॉपी अछि?
Receipt.
To send to any of your friends?
Receipt I will.
Passover कर दे. You are spoiling the entire effort of the court of listing and all.
Receipt. Apologize receipt.
And now there are two orders you are not even complying.
I file that's in the flag.
ठीक है करंतु then the next item to Mr. Sahoo.
May I please yes my lord I am on Vishi my lord. My lord, offense under section 307, 323, 325, 506, 379, 341.
My lord, directed to call for the CD and injury. That is not risk. So another date may make my lord.
Last two occasions, my lord, it was been directed to. But it was actually
after vacation or before vacation upon Chamchunti?
After vacation, my lord, I pray interim protection, my lord, because
interim protection is there, my lord.
There was no interim protection, but it was listed on 2 dates for obtaining injury report, but still now injury report has not been available. So I say, my lord,
upon say Mr. Dibyajyoti Sahoo, D.Sahoo for the petitioner. Mr. Rupananda Das AG for the state. The Learned Counsel for the petitioner refers to the earlier orders passed by the coordinate bench dated 23/5/2024 and 28/5/2024. The Learned AG submits that in terms of the said order dated 23/5/2024 and 28/5/2024, he has not received instruction and seeks further accommodation. As prayed for, list in the week commencing 24.
yes, ma'am. My date may be fixed, my lord. Date may be fixed because we
I am not the assigned bench. It doesn't look nice that I list all the matters in different benches. Why don't so that does
yes, my lord. Yes, I interim protection, my lord.
To move the assigned bench, that also I am observing.
Yes,
I don't know what is the listing and all that. I will direct listing and so on so date. In the week commencing 1/7/2024 for the assigned bench / moved by the petitioner. Sapare lekhuntu, in the meanwhile, there shall be no coercive action against the petitioner pursuant to the case details are deidebe, pursuant to FIR number so and so. Soft copy achi. Soft copy ta return karibe, order sarla pura correction pare tapare ferebe. Pen drive jota achi. FIR number so and so, GR number jaha bhi achi pura ta likhibe. Till 12/7/2024. Yes. Next, please.
May I please, Your Lordship?
Yes.
Lordship, kindly see the last order. The alleged offence mallet under section 379.
Lordship, culprit is not received matter, another date.
But my instruction is I have no criminal antecedent. But this honorable court directed me.
Affidavit deythante agya.
My lord, I have.
Upon affidavit they could have obtained instruction on basis of that affidavit. ଆଉ ସେଥିରେ 28(5) ରେ ଅଛି, it appears from the FIR that the petitioner is a habitual offender.
My lord, I have no criminal.
So then what can be done? You have to overcome that.
My lord, I have to file an affidavit.
Mr. S.K. Das for the petitioner, Mr. Arupananda Das AGA for the state. The learned counsel for the petitioner submits that in terms of the earlier order dated 28/5/2024, he is yet to receive instructions and may be accommodated. 21. Chabisi na chahiye ke na kebe?
Just reopening week, my lord, I will file.
As prayed for, list in the week commencing Chabisi, 6/2024 oblique moved by the petitioner. The learned counsel for the petitioner shall obtain instructions in terms of the order dated 28/5/2024. The learned AGA shall obtain case diary, up-to-date instructions. So oblique take likhibe, oblique criminal antecedents, comma, if any. Yes, next.
Last occasion, Lordship's call for the injury report. 307 case is there. As for instance, injury are simple in nature, Your Lordship.
Asichi?
No, but not received.
Injury ଅଛି ମୁଁ ତ ଦେଇଛି.
କେତେ ଥର time କେତେ ଥର
last 28 ଆସିଲା.
Injury simple.
ସେ ଆସୁ ଆପଣ ସେଟା ଦିଅନ୍ତୁ, you take interim protection. ସେଟା ଏବେ ରେକର୍ଡ କୁ କିଛି ଦରକାର ନାହିଁ. I am granting you interim protection till then. Mr. Parsuram P. Ponda, Parsuram Ponda for the petitioner, Mr. Arupananda Das AGA for the state. The learned AGA, referring to the order dated 28/5/2024, submits the list in the week commencing 8/7/2024 कर दियंतु 8/7/2024 oblique moved by the petitioner. Subpara, it is submitted by the learned counsel for the petitioner that he has obtained copy of the injury report, indicating therein that the
injuries are simple in nature.
The person injured in the alleged occurrence has received only simple injuries. Para. List in the week commission लिख दीजिए नहीं कि till 8th लिख ले. Till 12/7/2024, no coercive action shall be taken against the petitioner in connection with the PS case number so and so.
Naikandi PS case number. Naikandi PS case number.
PS case number
108/24. GR case number 535/24.
GR case number 535 of 2024.
Pending in the JMFC Basudepur.
Pending in the file of JMFC Basudepur.
The same.
Week commencing at no coercive action till 12/7. Yes.
Next item also same.
Same affair.
Same affair, same code.
Same order.
5366.
Aguru order 28/5 order ହେଇଥିଲା.
ଆଜ୍ଞା ଦିଟା ଜାଗା.
So that's 28/5. Yes. Yes, please.
Item 5, I may be permitted through VC my lords. On the last occasion, the Honorable Court had directed the state to obtain the criminal antecedent, injury report, and also the health condition report of the injured my lords.
Rajendra Narayan.
Simple injury, no antecedent.
Mr. Rajendra Narayan Raut for the petitioner, Mr. Arupananda Das, AGA for the state. the learned counsel for the petitioner refers to the earlier order dated 28/5/2024, wherein it was directed to obtain instructions regarding the injury sustained by the injured and criminal antecedents of the petitioner, if any. Stop. The learned AGA, upon instructions received from the investigating agency, submits that, as per his instructions, the person injured in the alleged occurrence has received simple injuries, and there has been no earlier criminal allegations against the petitioner. Para. Having heard the para likhiwe, the learned counsel for the petitioner submits that the petitioner is a local resident. He shall subject himself to the jurisdiction of the learned court in season of the matter and shall abide by the terms and conditions that may be imposed for grant of bail. That may be imposed, that may be imposed, tapar lekhontu, if the court is inclined to grant bail. Then para, the learned AGA, referring to the nature of allegations and the FIR, opposes the prayer for bail. Para. Having heard learned counsel for the parties, it is directed that if the petitioner shall surrender before the learned court in season within, Mr. Raut,
My lords, 3 weeks, my lords.
within 3 weeks, and makes a prayer for grant of bail, the same shall be allowed, subject to such terms and conditions that will be imposed by the learned court in season, as deemed fit and proper. The petition stands disposed of accordingly.
Deglobalized, my lords.
Yes, please. Urgent certified copy as per rules.
Offense, my lord, under Railway Property Act, my lord, the petitioner is the owner of the vehicle. The vehicle, my lord, involved in connection with the case, and the driver disclosed that the petitioner is the owner of the said vehicle, and on his confessional statement.
Saubhagya Kumar, yes, Mr.
Yes, on his instruction, the
ଆପଣ ଫାଇଲ କରିଦେଇଛନ୍ତି?
हाँ appearance form file कर दीजिए. As she is noting it. किंतु causeless stress नहीं.
हाँ, yes. Mr. Saubhagya Kumar, yes, Mr. Mahanti.
My lord, as per the allegation, my lord, he is the owner of the vehicle, and the railway materials were transported in his vehicle. And driver and other person who were interrogated, they have stated that as per his instruction, these materials were transported, and he is having a scrap material shop in Visakhapatnam. That is the allegation. Therefore, the
Letting go subject to such terms and conditions. Mr. Saubhagya Kumar Das for the petitioner.
subject to whether he is any criminal antecedent or not. That may be.
Yes. But I know I'll record his submission that there is no criminal antecedent. Mr. Das, that responsibility you have to take. If there is a problem, then the petitioner has to face that problem.
Well,
So Saubhagya Kumar Das for the petitioner, Mr. Gyanaloko Mahanti, senior panel counsel for the state for the opposite party.
Central government.
For the opposite party. The first paragraph so the petition under section 439 सेटा लिखि देबे आपण डिक्टेट करूनी पण जा लास्ट जा करछन सेटा कर देई जिवे आपण पाखरे अछि सेटा ता परे सेकंड पैराग्राफ मु डाकुची पहले so that we can save time. Family code it here not. Yes, railway सब कुछ नहीं पढ़ा के पढ़ दो ठीक है पर करें ब्रेक कर. It is submitted by the learned counsel for the petitioner that the petitioner has no direct involvement as much as the allegations of transportation of this railway property was beyond his knowledge. It is submitted that the petitioner is a local person, shall subject himself to the jurisdiction of the learned court in season of the matter and shall abide by the terms and conditions if the court is inclined to grant bail to the petitioner. The learned senior panel counsel appearing for the opposite party submits that the opposes the prayer for bail, indicating, referring to the nature of allegations and this is a complaint case or the FIR?
My lord, PR.
Prosecution report. जो लिखले first paragraph लिखना the second paragraph submission of the petitioner. So they add करिए गोटे line. It is submitted by the Learned Counsel for the petitioner that just add करंतु last add कर दियंतु that the petitioner has no such past similar allegations against him. तापर submission रहिला senior panel counsel तापर लिखा तो having heard the Learned Counsel for the parties, this court is inclined, it is directed that if the petitioner surrenders before the Learned Court in session within 3 weeks and makes a prayer for grant of bail, the same shall be allowed subject to such stringent terms and conditions that will be imposed by the Learned Court in session of the matter disposed of accordingly. Yes, next please. Mahapatra. Study Mahapatra. Pass over करते तो ठीक है 8 Mr. Pradhan.
Offense alleged under section 420, 467, 468, 471, 120B of IPC.
Yes.
Here, my lord, you will find the present petitioner is the wife of named accused. Named accused is Samir Patnaik. The present petitioner is the wife of Samir Patnaik. Well, what happened in this case? The Samir Patnaik was an accused in a Nandankanan PS case. This honorable court granted bail to him. There was a condition to furnish property surety of 3 crores. Property surety, one S.K. Makram Ali stood as a surety and a release order was issued. Subsequently found that S.K. Makram Ali is a fake one, and on the basis of forged valuation certificate, a release order was issued. So accordingly, London trial court recalled the order of release order and directed the bench clerk to lodge an FIR. But this is the FIR has been lodged pursuant to direction issued by the JMFCO. Now the FIR has been registered against the Samir Patnaik. The person committed crime is S.K. Makram Ali. But during investigation, it is found that S.K. Makram Ali died since 1999. His son and 3 others prepared a fake ID and impersonated S.K. Makram Ali, and bail bond was filed. This is the entire case.
The magistrate actually sent for inquiry to the concerned DSR, the district sub-registrar. So he says
yes.
Yes. Yes, Mr. Das, what is
so far my role is concerned, but I am the victim because I am the wife of Samir Patnaik.
But you are only apprehending that.
No apprehending. What he did, the investigating agency, forcibly took the 4-wheeler of my son. And now the 4-wheeler is in the custody of police and committing frequent raid to my house.
I have to obtain a CD, my lord, and an instruction, my lord, because I have nothing. They have also not stopped the legible copy of the FIR also, my lord, as per the direction.
Mr. Pradhan for the petitioner, Mr. Arupananda Das, AGA for the state. You are not the informant here?
Because what happened in this
JMFC पे आपण केमती अपेयर करछन?
On my yes, I am appearing.
Question टा सुनंतु. JMFC कोर्ट ऑथराइज कला पर मते देखंतु. I have to see that also.
What is happened?
आपण क्वेश्चन बुझले?
हां बुझली. May not be.
इंग्लिश ना ओडिया रे आपण कोथरे कहला.
Recent judgment of the
आज्ञा मु कोटे आपण recent judgment पचारले मते कहिबे. I have no problem.
No.
I am asking you, has the JMFC authorized you to appear in this case?
No. No, my
lord. Why you are saying that you are for the informant?
What the background of the case I am submitting, my lord? On my instigation, on my petition, the learner JMFCO.
My petition no. My petition no.
Yes, my lord.
No.
That is a mention in the warrant.
Tale say he will be in serious trouble, the officer and the JMFC will be in serious trouble. If what you are saying is correct.
Yes, that is correct. That is on record.
No, that's not on record. Upon the brief ta padantu. There is no presumption that the court will not read the brief. Mr. Budia.
My lord.
I don't know whether you have been provided with a copy or Mr. Das is provided with a copy.
I don't have the copy of the
When
bill.
मुझे तो आपको पचारिली जे this has been done तांको पचारिली से मतलब नहीं करना no this has not been done at the instance of the JMFC. Mr. Pradhan just whatever very fairly stated, but the last part I said, then how you say that you are the informant?
Informant only victim I mentioned because
you are not the victim as far as the impersonation is concerned. The entire issue relates to the property surety of 3 crores in Jatani, where Mohammed Akram's, Sheikh Mohammed Akram's ID has been forced by somebody. So, you are in custody. You are the informant where this the other person, the husband of the petitioner, he is in custody. Second jail na bahar achen.
He is in custody. In that order,
ଆପଣ ଯୋଉଟା bail prayer approach କରିବେ କୋଉଥିରେ କରିବେ JMFC ଙ୍କର FIR ରେ
because yes
that doesn't solve your purpose.
That is correct,
so I can't record your presence because then I have bail order ହେଲା ସେମାନେ ବି ଗଲେ Supreme Court, they went to the Supreme Court issues କଲା ପରେ ତାପରେ High Court information ପାଇଲେ. That is how I said that there can't be presumption that the court will not read the brief.
No, I am not saying that.
Here, this FIR is pursuant to the direction of the magistrate. After he discovered, after the registrar writes that these are not issued, the incumbency certificate or whatever certificate, valuation certificate is not produced by this office.
On my petition, madam.
No.
Yes,
no, please read the brief.
No.
If you are confident, I will pass over. You find out the order where it has been read that, said that it on my petition. In a bail application, what is your role? You are opposing the bail. So,
what?
Mr. Budhia, if I know I am wasting time.
No.
If I pass that order, then I am observing that in the bail application, the informant furnishes the guarantee, property surety. It becomes a laughable order. In which bail condition the informant will furnish the property surety? Upon application केमती आसिला ताले? You see, this is a allegation of producing fake document and fake certificate before the JMFC.
Yes.
JMFC directs for lodging of FIR. Upon order appear कले informant.
आगे सेथिरे मु पिटिशन देला ପରେ JMFC
देखन दे FIR टा मते आगे केतो थरा पचारिबी गोटे क्वेश्चन देखंतु FIR रे कोठी आपण informant
on my petition it was inquired.
ଆପଣ କେ ଭାବୁଛନ୍ତି ଯେ କୋର୍ଟ ବୁଝି ପାରୁନାହାନ୍ତି ମାଇ ପିଟିସନ has been inquired କଣ ମୁଁ ଚାର ଥର କହିଲେ ମୁଁ ବୁଝି ପାରୁନି ବୋଲି ତାର କହିବେ ନା ଆପଣ ବୁଝି ପାରୁନାହାନ୍ତି ଆରେ ମୁଁ ଗୋଟେ କ୍ୱେଶ୍ଚିନ୍ ପଚାରୁଛି ଆପଣ ତାର ଆନ୍ସର ଦେଲେ ଯେ ମାଇ ପିଟିସନ ଇଟ୍ ୱାଜ inquired. ଆପଣ କୋଉଠି ଏଫଆଇଆର ଆପଣଙ୍କର ଅଛି ଦେଖାନ୍ତୁ.
FIR I am not the informant in the FIR.
Sir, please, thank you. ଏଇଟା କଣ ହଉଛି କି ଆମେ ବେଳେ ବେଳେ ବହୁତ ସମୟ ନଷ୍ଟ କରୁଛେ ଫର ନନ୍ ଇସ୍ୟୁଜ.
What is the fact? I am brought to the notice of the court only.
Which fact the court missed? Which fact the court missed? You have brought to the notice of the court. Which fact? Sir, you are not sure of the facts.
ମୁଁ ନିଜେ ପରେ ଯାଇଥିଲି
ଆପଣ ଦେଇଥିଲେ ଆପଣ ପ୍ରପର୍ଟି ସାର୍ଟିଫିକେଟ ଆପଣ ଦେଇଛନ୍ତି ତାହେଲେ ମୁଁ ରେକର୍ଡ କରୁଛି
ଆକ୍ୟୁଜ ଦେବେ ମୁଁ କେମିତି ଦେବି?
Sir, then why you are going on? Why you are going on? I have told you that. You are making a strange submission that on my FIR it was not
my petition.
Sir, your petition objecting his bail. But FIR was initiated after as per the JMFC's order. ये जो माने अभ्यास जे कोर्ट पढ़ी नथिबे जानि परिबेनी जाहले ओटे कहबा
ना जाहले केमति कहबा ओटे हाई कोर्ट मीटिंग
you are saying that you see now everything is recorded. You must realize that we are in public gaze. You have already contradicted yourself. They're saying that I am not the FIR. I asked you that because since you are appearing for the informant, are you the informant in the FIR lodged by the JMFC? I categorically asked you. You are saying that the JMFC inquired after my complaint before the JMFC.
Yes, madam.
Understood. Can the court not understand that?
That is my submission.
Why you are wasting time? You are not the informant. And I am asking you if you are the informant, then show the FIR. Then you are saying I am not the informant. Obviously, you are not the informant.
That is correct. And the recent judgment of the Supreme Court, the victim can also appear at any stage of proceeding.
ମୋର ଆଜ୍ଞା ଜ୍ଞାନ କମ୍ ମୁଁ ଜାଣିଛି କିନ୍ତୁ ଯୋଉଠି ମୋର ଦରକାର ହବ ସେଠି ଦିଅନ୍ତୁ ଆପଣ ଏଥିରେ ଭିକ୍ଟିମ୍ ନୁହନ୍ତି ଏଥିରେ ଭିକ୍ଟିମ୍ ହଉଛନ୍ତି ଅଫିସିଆଲ have you realized what you are saying in recorded proceeding in YouTube you are not the victim the inquiry was asked of the JMFC the magistrate the learned magistrate asked for a report the officer writes that I have not issued it so he will be the victim it is so that is how I asked you that let us assume who will be the victim whose property has been produced as before the as property surety and you say that I am the informant so I asked you that have you furnished the property surety
No, madam.
then how you can be the victim the victim cannot be noticed also you will take notice of the victim he died since long his son and others they have done it
Madam.
Mr. Vishnu Prasad Pradhan for the petitioner. Mr. Arupananda Das, AGA for the state. It is submitted by the learned counsel for the petitioner that this is coming for the first time or order thila agru.
Last time file କରିଥିଲି 31/5 second time.
The learned counsel for the petitioner refers to the order dated 35/2024. Mr. Budhia, what has happened? You see, Mr. Arun Kumar Budhia, learned counsel and his associates have filed power on behalf of the informant, which is taken on record. This you have appeared before the coordinate bench, and this has been recorded.
I mentioned victim oblique informant. That is the.
You are not the victim because your property is intact. You have to be victim if your property is shown as a surety.
That is not there.
No, it is not there. It is Akram's property, but he has died.
In original case,
you see the difficulty you have created.
No.
Then how do you think that I do not know the honorable judge?
That cannot be.
He trusted you. What you are trying to do today also? The learned counsel for the petitioner refers to the order dated 35/2024. Submits that after the state order, the state has not received the instructions and oblique case diary. The learned AGA submits that he may be accommodated further to obtain up-to-date instruction case diary. Mr. A.K. Budhia, learned counsel is present, submits that he has instruction, he has filed wakalatnama on behalf of the informant. On being specifically asked whether on the basis of the FIR lost by ଆପଣ କାହା ପାଇଁ appear କରୁଛନ୍ତି ସେ କ'ଣ ତା ନାଁ କ'ଣ
କଳିଙ୍ଗ କେଶରୀ ରଥ କଳିଙ୍ଗ କେଶରୀ ରଥ
କଳିଙ୍ଗ କେଶରୀ ରଥ who Mr. Budhia submits that is the informant oblique victim sentence out there पढ़ंतु this sentence on being specifically asked whether the case the present case is emanating out of the FIR filed by ଆପଣ ଓକିଲତନାମାଟା କୋଉଠି ଅଛି ଯେ हार्ड कॉपी अपन पर अच्छी हाँ और लिख ले is arising out of the FIR filed by the Kalinga Kesari Rapta who has executed the FIR and statement of Mr. Budhia has been recorded by the coordinate bench in its order dated 35/2024 that he is the informant. Mr. Budhia fairly submits that the case has not been initiated at the instance of said Sri Ratha, but he is the victim in the alleged connected FIR. से FIR टा कोडा नंबर केते नाडा कोन Nandankanan PS case number.
Nandankanan PS case number
93 by 2022.
93 by 2022, whereas the present case arises out of
This case arises out
FIR
of
number
Bargad PS case number 57 by 2024.
Baragada
BADA
Baragada PS case number
57
of
2024.
57 dated 1 February 2024. तापर लिखंतु the learned AGSL obtain up-to-date case diary instructions. The learned counsel for the petitioner submits that the petitioner is being harassed by the investigating agency. The learned AGA denies the same said allegations and submits that the prayer for bail can be considered after the case diary and the instructions are received. Para. List in the week commencing. Mr. Das Kebe. 8 in the week commencing 8/7/2024. Para in the interim it is directed that there shall be no coercive action against the petitioner till 12/7/2024 pertaining to the FIR number please.
Bargad PS case number 57.
Bargad PS case number 57 of 57 dated 1/2/2024. City case pertaining to city numbers 102 of 2024.
Yes.
Yes, please. Yes, Mr. Budhia, satisfied?
Bas. I'll satisfy ଆପଣ କରିବ ସେଥିରେ କିଛି ଅସୁବିଧା ନାହିଁ ଅଟ ଯାହା କରି ଆଉ
ଏଇ ଗ୍ରାଉଣ୍ଡରେ ତାଙ୍କର ବେଲ୍ ଆଲାଉ ସେ ମିଷ୍ଟର ପ୍ରଧାନ ଛାଡ଼ିଦେଲେ ଆଜ୍ଞା ସେ ନୁହନ୍ତି ସେ କାଇଁ ଆପିୟର କଲେ ବେଲ୍ ଦିଅନ୍ତୁ ସେ ଛାଡ଼ିଦେଲେ
always satisfied ଯାହା ଅର୍ଡର ପାସ୍ ବାଇ ଏନି ଅର୍ଡର ପାସ୍ ବାଇ
ନାଇଁ ଆଜ୍ଞା ମୁଁ ସେ 22 ର ଏଫଆଇଆର କୁ ମୁଁ କେମିତି ଡାକିଦେବି 24 ର କେସ୍ ରେ ହାଉ କ୍ୟାନ୍ ଆଇ ଆପଣ କହିଲେ ସେଟା ମୁଁ ତ ସେଥିପାଇଁ ଆପଣ ଅର୍ଡରଟା ବି ଦେଖେଇଲି. The court believes you. That is how we are recording. It is not that every time we will go through the line by line and to understand the thing. Since the allegations are serious, obviously the court is looking at it. Yes, madam.
Item 9.
May I please, Your Lordship? Item VC, my Lordship.
Yes, Mr. S.S. Rai for the petitioner, Mr. Arupananda Das for the AGA for the state. Yes, Mr.
My Lord, initially case under section 341, 294, 323, 427, and 34 was registered, my Lord, against these petitioners.
Yes.
When the petitioner have surrendered before the learned court below is because the offences are bailable in nature. They are granted bail by the learned court below.
Yes.
Subsequently, my Lord, charge sheet, police has filed charge sheet on dated 31st/10/2018. By heading section 307 and 325, for which cognizance was taken on that ground, and the court has issued summon to this petition. Pardon?
427 punishment ketegi? Non-bailable
offences.
307 added. 307 added.
Added.
Madam, kindly see page 4.
Instruction achi.
Page 4 para 4 madam.
Acha, of the petition.
Madam.
Yes.
Issue summon to the that the printer they after getting bail on the police.
Upon order page 4 kuchun.
No, petition page madam. They have mentioned in the para 4 madam.
Acha.
In that
yes.
Cognizance is na 2018 नहीं आई.
हाँ, summon issue is summon issue.
16 so page 16 रे.
madam. हाँ. ना page 4 रे भी है.
हाँ.
Page 15, my Lord, kindly see the learned court below is granted bail to me.
What Mr. Rai is saying that 2/11/18 तो ना कौन सा था? Page 16 में देखो. 18. They were granted bail. So their apprehension of being curtailment of the freedom is
307 added, my lord.
Acha. Yes, what is your submission, Mr. Das?
They will appear before the lower
court and go on suitable terms. The petition under section so and so has been filed. Like 438 of CRPC has been filed as the petitioners. The petitioners apprehend, arrest by the investigating agency in PS case number 100 of 2018. ମୁଁ ଏଟା ଆପଣଙ୍କୁ ଗୋଟେ sample ଡାକି ଦଉଛି ବୁଝିଲେ କି, so that you also remain in track. Corresponding to GR case number 7667 of 2018 pending in the file of 767.
Yes.
ଆପଣ ଭିସିରେ ଶୁଭୁନି, ଆପଣଙ୍କ କଥା ବି ଶୁଭୁନି ମତେ।
ଟିକେ ଭଏସ କଟୁଛି।
Bill at this stage करते at this stage. Para having heard the learned counsel for the petitioner and the learned DG, this court is it is directed. If the petitioners appear before the learned court in session of the matter within 3 weeks and make prayer for grant of bail, the same shall be allowed, subject to such terms and conditions that would be imposed by the learned court in session of the matter. Stop para, disposed of accordingly. So after 10 we can take a break, resume at 2, and let us go serially. Instead of each category, we will try to complete the list, or from other category we should start taking.
No.
Because these are leftover matters. So let us try to. You have to sit for a little bit longer period. Beyond 3, last time it was 5:15, but maybe earlier.
You will complete by.
Please be ready for that. My point is that please be ready, have something and come back.
Yes, ma'am.
Item 10 ta khali sariya. So Patnaik, Patnaik.
The allegation under section 341, 323, 294, 327, 427, 506 of IPC, read with 31R, 31S of the SC and ST PO Act.
Yes, ST is there.
Pramod se order ta kar debe. Apon karthile Pramod Kumar eta. Same submission kar debe. File टा आपण तो रखिचंती देखे मु भी रखिथिबे मु देखिबी शेयर कर देबे लैपटॉप सिस्टम रे से ऑर्डर पास करिवे। Any suggestions, Mr. Das, to improve that upon that order, or simply paragraph 23 is that? So OLR citation टा से हम राति रे 10 टा बेले बही काढी दिया हिच OLR अछि आपण नै छिबे ऑर्डर अशोक प्रधान और ये करथिले गगन सामल करछ। Thank you. Sorry, कौन कहथिले मते?
नै मुकुल दीटा बस।
हां दीटा, yes. legible copy पाइले
Lordship.
दियंतु कोटे दियंतु देश लेके कपड़ा APL number item 1 लिखिबे item 1 Satyavrata Das for the petitioner Mr. Rupananda Das AG for the state A.N. Das. The learned counsel for the petitioner refers to the earlier orders passed by the coordinate bench dated 28/5/2024 and 23/5/2024 or 23/5 and submits that he is filing a legible copy of the complaint petition as directed in the said orders. Copy of the complaint petition is taken on record. Scan copy be updated. Copy has been served on the learned AG appearing for the state. The petition under section 438 of the CRPC has been filed as the petitioner apprehends. Pura complete karibe. Paragraph 1. Doubt hele pacharan. Any difficulty? Click period. Yes. Para 2, the counsel for the petitioner submits that the petitioner is a local resident, has shall subject himself to the jurisdiction of the learned court in season of the matter and shall abide by all the terms and conditions that would be imposed if the court is inclined to grant bail to the petitioner. Para 3, the learned AG appearing for the state opposes the prayer for bail, referring to the FIR and the nature of allegations. Then para, having heard the learned counsel for the parties, it is directed that if the petitioner appears before the learned court in season of the matter within 3 weeks and makes a prayer for bail, the same shall be granted by the learned court in season of the matter, subject to all such terms and conditions that would be imposed by the learned court, disposed of accordingly. Yes, next please.
Item 7.
None appears for the petitioner, though the matter is called twice over. Once when it reached and again upon resumption of the proceeding after the lunch break. To grant further opportunity to the petitioner, list when the petition is moved. Yes, next.
Item 11.
My lord,
Yes.
allegation under section 354, 354A, 294, 506 of IPC. My lord, petitioner is a assistant teacher of a government high school, namely Tapavana High School, my lord. My lord, there is a serious conflict between the headmistress and the petitioner, for which the petitioner made representation to the district social welfare officer, Khurda, annexure 2, my lord. My lord, kindly see last page of the brief, my lord, page 14, my lord. उक्त समस्त तथ्यावली प्रमाण जना पड़ुछि मोर कर्तव्यनिष्ठा समानुवर्तिता छात्र वत्सलतार स्थानित होई
ना कोन
माय रिप्रेजेंटेशन, my lord.
रिप्रेजेंटेशन भांडिको नाई कोर्ट
नो माय
समय नष्ट करंतु नि
my lord, sorry my lord.
जोडा का सुप्रीम कोर्ट रे जदि अछि ताले देखेबे डोंट वेस्ट हम ऑलरेडी बहुत समय नष्ट करि सारलेनी.
My lord, the allegation is at the time of teaching, my lord.
सेटा तो एफआईआर अछि.
They
So serious allegations.
my lord, they are abused in the field language.
हां तापर कोन हला से कोन तो अपन से गवर्नमेंट सर्वेंट
Government servant, teacher, my lord.
Yes, Mr. Das. जानतो subject to such ये देखिए Mr. N. Patnaik for the petitioner, Mr. N. Das, Achyutananda Patnaik or Rupananda Das, both हैं. Yes. So A.M. Das for the AGA for the state. The the petition under section 438 of the CRPC has been filed as the petitioner apprehends. So and complete career. Arrest and so and so. Para 2, same. Para 3, same. Para 4, same, subject to such stringent terms and conditions. The stringent what add kar de. Disposed of accordingly. Okay. Yes, next.
Item 12.
Yes.
12, may I please?
So Satyavrata Panda.
My lord. Here, my lord. The present petition.
When you made for the last time, you suggested that you will go through CRPC, IPC and Constitution. Have you completed
Because
that?
now it is invalid, my lord. April 1 new Nyaya Samhita.
April. No,
Yeah, July 1.
That I'm having, you can see.
My lord.
Those blue 3 books are.
So
I've
these are
already
now
gone through that.
going to be invalid. Partly.
So you are not reading that.
Partly.
It's good that you have spent 3-4 months for reading that, and by the time you read complete reading, it has become invalid. And what about Constitution?
Constitution, I have not got.
Oh, so but you said very seriously that going to be invalid. So I thought that
Constitution, my lord. In view of Constitution, my lord, we are trying to change, but the mandate has not come with favor.
No political statements. You confirm it to the profession.
Right. Here, my lord, the present petitioners are, my lord, elder father.
All presumptions are good, so it should be good.
Here, my lord, the present petitioners are, my lord, elder father, brother-in-law and wife, his wife. 490. In view of honest Kumar, your lordship may dispose.
No, dispose of केमती कर दवा. अपन सिथिरे अच्छी, सिथिरे victims' rights are more enhanced.
I have also made our party. Your lordship may see.
You have thrown the girl on the street.
Yes.
Mr. Panda.
Yes.
Item 12.
Item 12.
Satyavrata Panda for the petitioner, Mr. A.N. Das for AGA for the state. Para 1 gola, 2 gola, 3 be same. Para 1 is the narration, para 2 is the submission of the petitioner. Para 3 is the submission of the AGA. Para 4. But para 3, AGA submission lekhantu, the learned AGA referring to the allegations and the contents of the FIR opposes the prayer for bail and submits that he may be accommodated to obtain up-to-date case diary instructions in the matter. Accordingly, it is directed the case diary up-to-date instruction stage of investigation, public trial shall be obtained by the next date. List in the week commencing 8/7/2024 before the assigned bench. No coercive action shall be taken against the petitioners in connection with the above case till 12/7/2024.
Obligement.
Yes, please.
I may be pardoned, my lord. Item number 7, my lord, I have missed it.
Sir, please don't disturb the proceeding, sir. Please don't disturb the proceeding. So it has been adjourned. It has been adjourned, so don't worry.
My lord, non-appearance may not be recorded, my lord.
No, that cannot be.
I may be pardoned, my lord.
Now you are beyond recording of the court because everything is been recorded live, available in the YouTube. Both your non-appearances and my observation are recorded.
Pardon, my lord.
The thing about something that when people start directing deletion of those recorded portions. So no.
My lord, there was a network glitch, my lord. So I may be excused to that effect. My lord.
I would have dismissed if I would not have excused. Then I would have dismissed. And vacation, we have to take urgent matters. We have only half an hour left of the official time. Please appreciate. We should not spend time on this, please.
Obliged, my lord.
Yes, please.
May I please proceed?
Yes.
And offense 294, 323, 341, 342, 354, 379, and 507 official lordship. So this is a political dispute. In the FIR it is mentioned that the informant who is a BJD netri card dhari.
ये antecedent कहाँ अच्छी?
So one antecedent.
ठीक है जी, instruction नियंतु same order. Same order कर दियंतु. Same order in the sense आपण last टा कोटा गला 12 जहाँ 13 से आओ 8 week रे आसीबो 12 हो जाएगी ঠিক আছে।
Lordship permitted to withdraw as the petitioner has already got arrested. I have filed already, the memo is attached.
Okay. Mr. Kuldip Mohanty was there.
My boss.
Present. You have power.
Yes.
It's A. Das
Yes.
for the petitioner. Mr. A. N. Das for the AGA for the state. And counsel for the petitioner submits refers to the memo
Withdrawal.
on record marked as flag X. Marked at flag X, not as, marked at flag X to withdraw the petition. Subpara, the petition stands dismissed as withdrawn. Yes, please, next.
Item number 15, Lordship.
Sorry, please.
15.
15 your matter.
Yes. Lordship, item number 15, 307 allegation is that the injury is simple in nature, the dispute regarding between the political library.
Asibe na apon nebe eta. Asibe. Just a second. Everyone is little bit overstaged, so please also appreciate that.
This is asserted by Bhujal in the neck, my lord. Let the injury report be called for.
Acha.
Injury is simple in nature that
But unless we see that on record, that's the difficulty. Interpretation देखी
not
same order कर दियो.
no criminal.
अच्छा आरंभ करंतु ताले आपण चेंज होला. आपण ने आसीबे सेटा लास्ट मैटर टा केदे जायतला एटा होची 12 15 सेमास 12 डेट खाली चेंज कर दियंतु will be listed in the week commencing 15/7/2024 interim order there shall be no coercive action against the petitioner till 19/7/2024 कल डेट डीटा चेंज होची yes next please आनिबे अप टू डेट केस डायरी इंजुरी रिपोर्ट 15 रे इंजुरी रिपोर्ट ता कॉल करिवे ऑर्डर अच्छी इंजुरी रिपोर्ट ऐड कर देते DS 16 please.
Offences are under section 379, 279, 307 and 422 along with other offences. And this is an allegation of illegal transportation of cattle. And
so let CD come. It item kete dakchunti 556 16 item 16 lekhantu. But call ela bele note kar diyo tal bhola hone. What I found yesterday the last occasion that the orders passed in 3-4 of bills, bail orders have been mixed up along with the IA. Not all the stenographers, but that is happening. 16, Mr. Bikram Ratha. Mr. Bikram Ratha for the petitioner, Mr. Arupananda Das AGA for the state. The petition under section 438 of the CRPC has been filed as the petitioner apprehends arrest in so and so PS case number ette, GR case number ette, pending in the file of so and so. Likhiye pura. Yes, what is your submission, sir?
submission is
Okay. The learned AGA, referring to the allegations, opposes the prayer for bail, submits that he may be accommodated to obtain up-to-date case diary instructions and past allegations of criminal activity, if any, against the petitioner. Para, as prayed for, late case diary, up-to-date instruction, status of investigation, including criminal antecedents, if any, be obtained by same 15 कर दो ना तो earlier आनी पड़ेगी 15/7/2024 no coercive action against the petitioner shall be taken pursuant to the above in the above case, not pursuant to, in the above case till 19/7.
Not only one, my lord.
I'm so sorry. So this has been switched. I'm so sorry. You obtain list in the week commencing कौन लिख ले? ता पूर्व list in the week commencing before the assigned bench public moved by the petitioner. ता पर पारा लिखिबे last पारा no interim order, no coercive action. In the interim, it is directed that no coercive action shall be taken against the petitioner in the above case till 19/7.
Petitioners.
Yes.
17. May I please?
Yes.
Miller, the offense under 379, 411, 34 IPC related to 7 prevention of chaos alter at the illegal transportation of the
Say last matter just say it. Same.
And the present petitioner is the
Same as 16. Say 15 public moved by the petition. You have to move for listing, but the interim protection is 19. Suppose it is upon the aguru bi jodi list kari parle move kari ki bhala kotha. That is how it is written also.
problem.
But apan to etre na nahi.
On behalf of Bharat Jali.
You are Mr. Mahapati.
Satpathy.
Mr. Satpathy.
Somnath
Satpathy. Mr. S. Satapathy on behalf of B. Jali for the petitioner. 18.
18.
On behalf of Mr. Chand, my lord, kindly have after vacation.
Yes, you are Mr. Gowda.
K. Badhai.
Mr. K. Badhai on behalf of M.K. Chand for the petitioner. Mr. A.N. Das, AGA for the state. Learned counsel for the adjournment is sought for on behalf of the learned counsel for the petitioner. As prayed for list after vacation, moved by the petitioner. Yes, please.
19.
Mr. Asit Kumar Jenna for the petitioner. Mr. A.N. Das, AGA for the state. Yes, Mr. Jenna.
Allegation of 379, 411, 120B, IPC and section 21 of MMD Act. Transportation of coal, my lord. I am the owner of the vehicle. Okay. It was seized by the, my lord, the sub-inspector of police, my lords, and who lodged the FIR. 2 drivers had been caught red-handed on this.
So let them obtain instruction. You relate that to interim protection. Same order.
My lord.
12. ଆପଣ ଆରମ୍ଭ କୋଉଠୁ କରିଛନ୍ତି 15 listing date share ରହିବ in the week commencing 15 interim order till there shall be no coercive action till
your lordship say till next date, so that if it is not being listed, say
protection ta fixed. Listing you can list it on 1st, 24th, 18th. ଆପଣ move ଯେବେ କରିବେ you may be granted bail also. Protection is fixed. That is how you smile. Good. Deep one. Yes.
20.
Mr. Sarthak Satpathy for the Mr. S. Mahanti. Mr. Shashwat Jena for the petitioner. Sorry. Mr. Shashwat Jena for the petitioner. Mr. A. Das, AJ for the state. Yes.
May it please, Lordship, the present application is filed by the petitioner.
379, same order.
Let's say, the only my implication is that FR in the page 12, 15th line from the top, my name has been implicated by the apprehended person. That I and him were running the shop.
So let them obtain that instruction. You will. So same order.
Obliged.
21.
Let on Deva Ambligatna Panda, I may be permitted.
Yes. Mr. Raut, SK.
Satyajit Raut.
Satyajit. क्या मो सबले SK को जो मुझे पने वाला तरह SK कोई थी Mr. S. Raut on behalf of A.R. Panda for the petitioner. Mr. A.N. Das, AGA for the state.
The case of offence under section 498A, 323, 50.
ये हो चुकी केस आसु.
ये ला
नॉनंदो ही थी.
नॉनंदो. And every person were released on bail by the police.
The instruction new to same order. Listed in the week commencing 15 oblique लिखिबे moved by the petitioner. Upon bill, there is no bar that you cannot move. Please appreciate this. I am not putting any bar of moving the petition. So oblique always it is mentioned that on being moved by the petition. Protection till 19th.
Well.
Yes, Mr. Banerjee. Paile order sheet पाई गले.
ଆଜ୍ଞା ଆଜ୍ଞା ସେଟା ଆର କେସଟା 35 ରେ ଅଛି
ଓ
ଅର୍ଡର
ଏଇଟା କଣ ଏଇଟା ବେଲ୍ ଜମ୍ପ ନୁହଁ
ନା ଏଇଟା ବେଲ୍
ଏଇଟା ପ୍ରପର ବେଲ୍ ଜମ୍ପ କରିନାହାନ୍ତି ଠିକ ଅଛି 8 to jump ତାହେଲେ ସେମ୍ ଅର୍ଡର କଣ ହେଇଛି କି
506 ହେଲା ଓନ୍ଲି ନନ୍ ବେଲେବଲ ଆଉ
307 ଲାଗିନି କି
ନା କିଛି ନାହିଁ
ଚାର୍ଜସିଟ୍ ବେଳେ 307 ଲାଗିଥିବ ଦେଖନ୍ତୁ
294 341
ଆପଣଙ୍କୁ ତ ଲୋର କୋଡ କହିବେ ଯେ ଲୋର କୋଡ କହିଲେ ଆଜ୍ଞା ଦେଇନାହାନ୍ତି ମୁଁ କେମିତି ଜାଣିବି
ନା କେସ୍ କାଉଣ୍ଟର କେସ୍ ଆଜ୍ଞା
କେସ୍ କାଉଣ୍ଟର ସେ ଆପଣ କାଇଁ ଚାର୍ଜସିଟ୍ ଦେଖିଛନ୍ତି ନା ମିଳୁନି
ଚାର୍ଜସିଟ୍ ହେଇନି
ଆଜି ଗୋଟେ ଥିଲା ସେ 307 ଲାଗିଗଲା ତ ଦେଲା ବେଳକୁ
ଫେଷ୍ଟିଭାଲ ଗାଳି କରି ସେଥିରେ ବି ନାହିଁ ଏଫଆଇଆର ବି କିଛି ନାହିଁ
ମିଷ୍ଟର ମୃତ୍ୟୁଞ୍ଜୟ ବାନାର୍ଜୀ ଫର ଦ ଆପଣ ମୃତ୍ୟୁ ଲେଖୁଛନ୍ତି MRI TUN Mr. M. Banerjee for the petitioner, Mr. A.N. Das for the AGA for the state. First para, second para gala. Second para kon daki debi. Acha eta daki doji bode. The petition under section 438 of the CRPC has been filed as the petitioner apprehends arrest in connection with G.R. case number 300/2024. In the file of the learned court of the SDJM, arising out of Chandanpur PS case number 106 of 2024. It is submitted by the learned counsel for the petitioner that there is only one allegation which will lead to a non-bailable offence. The petitioner has no past allegations of criminal activity against him. He being a local person shall subject himself to the jurisdiction of the learned court in season of the matter and shall abide by the terms and conditions that would be imposed if the court is inclined to grant bail to the petitioner. The learned AGA, referring to the FIR and nature of allegations, opposes the prayer for bail. Having heard learned counsel for the parties, it is directed if the petitioner surrenders within 3 weeks before the learned court in season of the matter and makes a prayer for bail, the same shall be allowed subject to such terms and conditions being imposed by the learned court in season as would be deemed fit and proper. Stop. Disposed of accordingly. Yes.
Item 23.
ठीक है जी पासवर्ड करता हूँ
24.
May I please the losses?
Yes, please. Mr. Vijay Kumar B.K. Parida, -2, English 2, for the petitioner, Mr. Arupananda Das, AGA for the state. Yes, Mr. Parida.
Offense under section 498A minor. Petitioners.
Principal accused.
No, 3 petitioners are Swami, father, mother.
Interim protection is there. Same order as interim protection. In the week commencing 15, no course of action till 19. Oblique driver to move by the petition.
25.
May I please the lordship?
Yes.
Well, offences under section 341, 323, 324.
You are Mr. Dora.
Jagannath Gochayat.
Mr. J. Gochayat. Mr. Jagannath Gochayat for the petitioner. Mr. A.N. Das, AGA for the state. Yes, Mr.
Allegation is when the informant was returning to his house. At that time, the present petitioner, along with others,
आपका केवल 307 है highest offence.
394, 397.
अच्छा.
397.
ये कौन?
But as far part is concerned, I have no role in this case.
ठीक है जी से आपण interim protection
in this case, the compromise.
Interim protection देबेनी. देबेनी arrest हेबे.
My lord, compromise has been drawn by both the parties.
सेटा सेठी हो ना.
And he has given the
438 रे compromise सेमती किछ नाही. मो अगर जेती की जानची कर परिबे ना 438 रे compromise भी कर देबी. APL रे compromise order केमती करिवि. So you can file that on affidavit or the joint affidavit.
The informant has filed an affidavit. In that affidavit, it is clear stated.
Without you cannot represent both the informant and the opposite party. Please be conscious. And there are 2-3 members of the bar council are present here. He himself.
My lord.
So you don't do that. Develops a
Aye.
And always be patient also. Or impatient won't.
My lord.
ଟିକେ ବସନ୍ତୁ କିଛି ପାସ୍ ଓଭର ହେଇଥିବ ଏଟା ଆପଣଙ୍କର ଇଣ୍ଟରିମ୍ ପ୍ରୋଟେକ୍ସନ ଦେଇ ଦିଅନ୍ତୁ ଇନଷ୍ଟ୍ରକ୍ସନ ଦେଇ ଦିଅନ୍ତୁ
My lord, one.
ହଁ ୟେସ୍ ପ୍ଲିଜ ଯେତେ ଥର ଇଣ୍ଟରିମ୍ ପ୍ରୋଟେକ୍ସନ ଦେଲେ ଆପଣ ଅପୋଜ କରୁଛନ୍ତି ମାନେ ଯଦି ଷ୍ଟେଟ୍ କହିବେ ନା ଟାଇମ ୱେଷ୍ଟ କରନ୍ତୁ 10 ମିନିଟ ରହିଲା ଅଫିସିଆଲ ଟାଇମ
As per assault part is concerned, I have no role.
yes अरे sir, who is how the court will say that you have all the rights of bail granted? Simply naive law. Though the petitioner is the principal accused and the allegations has made against him, still he is granted anticipatory bail. Simply order lekha jayeni.
No, FIR is.
So jaha bhi achi FIR is not FIR role kon substantive evidence.
No one.
Court decision ne कहला substantive evidence FIR. ଆପଣ କ୍ରିମିନାଲ ସ୍ପେଶାଲାଇଜ କରିବେ ଦେଖିବେ ଏଫଆଇଆର ଇମ୍ପୋର୍ଟାନ୍ସ କଣ whether FIR is admissible evidence relevancy admissibility weight even it can be said that FIR is not that relevant it is only relevant it's not gospel truth तो काई सिते जाउचंती हम जेते तरह कहली इंटरिम प्रोटेक्शन आपण ऑब्जेक्ट करचंती डोंट ऑब्जेक्ट व्हेन द कोर्ट इज इन योर फेवर
माय लॉर्ड ओब्लेस माय
अब समय अभाव रे घोर समय अभाव अछि यस
विथ ग्रेट रेस्पेक्ट माय लॉर्ड
No, please. I also say with the utmost respect. It's a discussion in the across in the bar.
My lord, bless.
Yes. In the it will you can move it or in the it is listed it is to be listed in the week commencing 15 protection till 19. Say part बुझे आपण बुझिबा दरकार so that आपण को तापर अर्जेंट सर्टिफिकेट कॉपी रहइबो Yes, call them.
Sir, may I please your lordship?
नहीं ଆମର ଏବି ମିଟିଂ କୋ ଯାଏ ଅଛି କି ତ ଅଛି ପାଖରେ ଟିକେ ଅଳ୍ପ ଅଛି ମ୍ୟାଟର ଆମର ୱିଲ୍ ଶିଫ୍ଟ ଟୁ ଦ ଅଦର ଟିକେ ବସନ୍ତୁ ଆପଣ ଅନ୍ୟ କୋଉଠି ଯିବାର ଅଛି କି ତାହେଲେ ଟିକେ ମୁଁ କହି ଯାଇଥିଲି ଆପଣ ଖାଇକି ଆସନ୍ତୁ ମୁଁ ମୋର କାମ ଦାମ କରି ଖାଇବା ପାଇଁ ଟିକେ ଦୂର ତାହେଲେ ତ ଭଲ କଥା ନାଇଁ ଦେ ଆର୍ ୟୁର ରାଇଟ୍ ମୁଁ ତ ଖାଇବି 2ଟା ବେଳେ ଖାଇଲେ ତ ଟିକେ ସମୟ ଲାଗିଲା ତେଣୁ ଦେ ଆର୍ ୟୁର ଆବସଲ୍ୟୁଟଲି ରାଇଟ୍ ୟେସ୍ ଆଇଟମ୍
23 ma'am.
26.
May I please lordship?
Upon associate will. Sorry. Yes.
This is
Mr. Purnachandra Maharana.
Dilip Kumar Sahu.
Mr. D. Sahu. Dilip D.S. Dilip Sundar.
No, Dilip Kumar Sahu. Yes.
Mr. D.K. Sahu for the petitioner. Upon not a bill like
again.
Acha. Mr. A.M. Das, AGA for the state. Yes, please. Next.
This is covered under 6. No. 360. 360.
Pramod Kumar, that judgment, the order I have passed. The 3 SC the Pramod Kumar ye kar debe.
Obligement.
Yes, please. So, OLR report rechi, jamu dekhili, initially I had dictated and finalized the order on the basis of India canon, but it is same.
Same.
15.2 there, page 44. Yes.
27.
Yes, next. 27.
My lord, allegation under section 379 and
Mr. M. Khotua is of the petitioner.
Allegation under section 379, 411, my lord. And co-accused persons have been granted bail by my lord.
से आनंद समस्त को जेतु माने दिया जो इंटरिम से पे मु फाइनल ऑर्डर करे को because it there should be uniformity. So interim protection दे देबे till 19th, list on 15th oblique when moved by the petitioner. Yes. Week list in the week commencing 15/7/2024. In the interim, it is directed there shall be no coercive action against the petitioner in the above case till 19/7/2024.
May I please, Your Lordship, 28.
Yes, 28.
Allegation of offense is
A. Das for the petitioner. Mr. A.N. Das, AGA for the state.
Allegation is of Your Lordship 457 and 380. Petitioner is the intimate neighbor of the informant and on
Immediate neighbor. There is no intimacy. They are worrying. They are now worrying.
Sorry.
So highest punishment kete?
7 years is there.
Dibya kare?
5 years or 7 years.
Jantu tale? Na instruction anyway.
He has no role.
No, you have to have some suggestion.
Surrender and move বিপরীত
ঠিক আছে তাহলে সে তাহলে লিখন্তু ফার্স্ট প্যারাগ্রাফ গলা the petition under section 438 of the CRPC has been filed by the petitioners not petitioners as a apprehend's arrest in so and so
Lordship,
counsel for the petitioner submits that para 2 re likhibe as per the FIR story the petitioner has no past allegations of criminal activity against him. He is a local petitioner. He is a local resident. Shall subject himself to the jurisdiction of the learned court in season of the matter, and shall abide by the terms and conditions that would be imposed if the court is inclined to grant bail to the petitioner. Learned AGA, referring to the affair and the nature of allegations, opposes the prayer for bail. Having heard the learned counsel for the parties, it is directed that the petitioner, if the petitioner appears before the learned court in the season of the matter within 3 weeks and makes a prayer for bail, the same shall be granted subject to such terms and conditions that will be imposed by the learned court in season of the matter as would be deemed fit and proper, disposed of accordingly.
Lordship, at the time of filing this application, the GR case was not registered. That's why I have given gap to that GR case number. And now it is registered.
GR case number, first paragraph, GR case number
977 of 24.
977 of 2024 in the file of
Learned SDJM Kendrapada.
Learned SDJM Kendrapada, arising out of in connection with FIR number, PS number, so pocket debe. Yes.
Okay.
29. May I please, Lordship, I am submitting through VC, my lord.
Yes, please.
And 307 is the highest offense, my lord.
You are vacation, I mean, so, visiting some place or at your home?
At home, my lord, I was there before launch because it is Savitri.
You have become Satyavan. Fine. Why Satyavan is second half? The scorching heat. All of us, we tried to win the first half.
I was there, my lord, because it was Savitri. I was forced to come here, my lord.
So instead of writing SN likhibe, today you write SB Misra. Or you write S Misra. No, because your name can be taken that liberty. It can be S. Misra. Mr. SN Misra for the petitioner, Mr. A.N. Das AGA for the state. Yes. Mr. Misra.
Yes, ma'am. Dispute with the family members. Both are one family man. 307, my lord.
207 acha lagi 307.
CD interim protection, my lord, even CD injury protection.
He's not making any submission regarding whether simple or yes, so let it interim protection. We commencing on 15/7, protection till 19/7.
Obligement.
Yes. So you are performing in presence of Savitri or you are
Savitri is here, but inside, my lord.
Item 30. My lord, I am on VC, my lord. Item 30.
Mr. Rai, yes. So
354, 380.
ଆପଣ ସକାଳୁ ବ୍ୟସ୍ତ ଅଛନ୍ତି ଆପଣ ବିଲକୁଲ ଆସିନାହାନ୍ତି.
My lord, my mother is ill, my lord.
Yes, somebody mentioned on your behalf regarding her illness. Take care. Mr. S.S. Rai for petitioner, Mr. A.N. Das AGA for the state. Highest con 307 है
54 380 he was not named initially. After filing of charge sheet he was named. And other co-accused person have been granted bail by the court below as well as the Honorable High Court.
2007 FIR.
Yeah, 2007.
The first paragraph, the petitioner apprehends arrest through लिखिले complete कले para 2 लिखिवे. It is submitted by the learned counsel for the petitioner that the FIR out of which the matter arises, that is ASCA into bracket Ganjam 118 of 2007 कि जे कौन सेंटेंस टा बोलेला तो पढ़िले submitted. The incident pertains to an FIR. The incident pertains to an FIR of the year 2007. That is FIR number 118 ASCA into bracket Ganjam oblique 2007. It is submitted that during pendency of the trial, some of the persons have named the petitioner. Therefore, he is apprehending arrest. No past allegations.
No, man.
ଏଇଟା କେମିତି ହେଲା ଆପଣ ତ ଫାଷ୍ଟ ଆଲିଗେସନ 10ଟା ଖଣ୍ଡ ନଥିଲେ ଆପଣ ତ ଆସିବା କଥା ନୁହଁ
କିଏ କିଏ ଗୋଟେ କହିଛି କଣ ଗ୍ରୁପ କ୍ଲାସ
my esteemed brother in court that it appears that the petitioner has a past history of allegations. It is no past allegation of criminal activity against no similar allegations. No similar allegations. Further submitted, further submitted, the petitioner is a local person, shall subject himself to the jurisdiction of the learned court in season of the matter and shall abide by the terms and conditions that would be imposed for grant of bail if the court is inclined to do so. The learned AGA, referring to the nature of allegations, opposes the prayer for bail. Having heard learned counsel for the parties, it is directed that if the petitioner appears before the learned court in session of the matter and makes a prayer for bail, the same shall be granted subject to such terms and conditions that would be imposed by the learned court in session of the matter. No, sorry, correctly, imposed as being fit and proper, subpara disposed of accordingly. Yes.
One minute, please, your lordship.
You are Mr. Behra.
My lord.
Mr. B. Behra for the petitioner. Mr. Arupananda Das, AGA for the state.
Alleged offense, my lord, under section 342.
Injury, nature of injury, janchanti.
The nature of injury, my lord, one grievous injury. That has
been condition anantu. First, the petition under section 438 of the CRPC has been filed as the petitioner apprehends arrest in connection with so and so, for detail likhibe. Para. It is submitted by the learned counsel for the petitioner. It is submitted by the learned AGA that he may be accommodated to obtain up-to-date case diary, present health condition of the injured, as well as past allegations of criminal activity against the petitioner, if any. Para. Accordingly, it is directed the up-to-date case diary, instructions, present health condition of the injured person, victim, shall be obtained. A criminal antecedent criminal antecedent be obtained by the next date. List in the week commencing 15/7/2024. Para. In the interim, it is directed there shall be no coercive action against the petitioner in connection with the above mentioned case till 19/7/2024. Yes, please. Next. Yes, Mr. P.K. Das. Yes, ma'am. For the petitioner, Mr. A.N. Das, AGA for the state. Yes, Mr. Das.
Yes, Miss. Between the two groups, not the arising out a political dispute in the village blood, your lordships can turn to.
Yes, answer. Yes, right. No allegations, past allegations.
That, my lord, that the information is that, my lord, intimation that petitioner is the ex-sarpanch and the Panchayat Samiti member. More probably that political person, there's some antecedent there.
Could be. Teach Adam. The petitioner, the petition under section 438 of the CRPC has been filed by the petitioner. As he apprehends arrest, it a singular apprehends arrest in connection with GM number. The learned counsel for the petitioner submits that the petitioner is a local resident, shall subject himself to the jurisdiction of the learned court in session of the matter, and shall abide by the terms and conditions that may be imposed if the court is inclined to grant bail. The learned AG, Mr. Das, you are the, because today it is all Mr. Das's stay.
Yes.
So, Mr. The learned AG, referring to the nature of allegations and the FIR opposes the prayer for bail. Having heard the learned counsel for the parties, it is directed if the petitioner appears before the learned court in season of the matter within 3 weeks and makes a prayer for bail, the same shall be allowed subject to such terms and conditions that would be imposed as would be deemed fit and proper by the learned court, disposed of accordingly. So, Ketra Gote? 23. Yes.
My lord, offense under section 52A, 46 Excise Act, my lord. At the time of election, se dukan le rokhitala kisi purchase from the license shop, my lord. Koi se dukan lo darala beer bottle
Into na din tagar bagho nahi ki. But he is not that terrifying according to your submission. Bagha ki bagho iti wo?
Bagha. Bagha alleged.
Yes, Mr. Das. Surrender and जान तो हो जाए क्या? कल सेम ऑर्डर कर देना. अपन एबी जोटा लास्ट मैटर टा कले, that is 30 हाँ, last is 32 बधे, 32 same as 32 कर दे.
Obligation.
Within 3 weeks. Yes.
Urgent copy.
Yes, please. Urgent certified copy as put.
33.
May I please, Your Lordship?
Yes, Miss S. Jenna, Sorabala Jenna.
Your Lordship, Jacqueline Jenna.
Mr. Jacqueline Jenna. Mr. Jacqueline Jenna. J. Jenna. M.S. J. Jenna. For the petitioner. Mr. Karunakara Das AC for the state.
Last as per the CD that is not received. If the offense under section 302, the LIC.
No, I would brief the The standing counsel vigilance. 20409
No, Your Lordship, vigilance was inadvertently added and on the last occasion a copy was served by the state council, Your Lordship.
302 or Chitre?
No, Your Lordship.
420.
420.
Your Lordship, 420 and 409 of IPC, Your Lordship.
What's the allegation?
Your Lordship, the complainant has alleged an amount of 27. Your Lordship, 12 lakh is the allegation made by the LIC officers, Your Lordship. However, only one policyholder has come out to complain.
Serious allegations.
Your Lordship, if
what you have done, it has spoiled both ways. The insurer's life that in the sense is secured. Security has gone. Company has been duped of the amount.
But Your Lordship, may kindly appreciate, Your Lordship, I am the LIC agent, Your Lordship.
Yes, that is more so. You acted in fiduciary relationship. They may face criminal charge. And the persons who sought for the insurance of the life being insured, they are put at jeopardy.
No, but Your Lordship, the whole basis of allegation is that if Your Lordship may kindly see in page.
So you know that you have to think about securing those amounts so that the LIC policies can be issued. You obtain instruction.
Your Lordship,
because the adverse order I am not passing now.
Your Lordship, already 1 lakh odd has already been refunded by the petitioner on the direction of
1 lakh odd. How does it matter when they are saying 27, you are saying 12? According to it is 12.
No, Lordship, I'm not saying 12, Your Lordship. Only one claimant has come claiming 27,000, Your Lordship.
No, the rejection.
As of now, only one claimant is there, Your Lordship.
Is that a matter which is relevant? You see, you have to be particular in your submission. You have to say that he's the only person who was seeking LIC.
Yes. No.
Then I'll ask them to obtain instruction. It can't be both ways. You have to be very particular about your submission. That I am only the money towards premium received from only one person has been.
Yes, Your Lordship.
Utilized.
Your Lordship, only one claimant has.
But I don't think you are that confident. So don't make a submission which will act against you.
Your Lordship,
suppose now I record that. Next time they come up and say that no, he has received commission, the LIC premium for about say 20%. And your
Lordship will find
for that reason, it is the best interest of the client or for you also. Let them file that affidavit. Why you are taking on to yourself?
No, Your Lordship, it is there in the FIR. However, Your Lordship, today, if Your Lordship may kindly permit, I am pressing for interim bail, Your Lordship, because the petitioner, if Your Lordship may kindly turn to page 20.
Interim application kind.
Your Lordship, I filed an IA for interim bail, Your Lordship.
I said, कितना number? IA 621.
Yes, Your Lordship, 621. If Your Lordship may kindly turn to page 20, Your Lordship, the petitioner is 80% locomotive disabled, Your Lordship.
More the reason he should not have indulged in these kind of activities.
I admit, Your Lordship, but
A
however,
person having locomotor disability should not start cheating people. He has a different perspective of life. He knows how difficult it is to earn money.
Your Lordship, my submission is that, Your Lordship, the petitioner is being made as the scapegoat, Your Lordship, simply because the.
You see, I can't direct that the petitioner is a scapegoat, 80% look. So you have to bring something substantial to allow regular bail.
I bow down, Your Lordship.
So you bring that amount.
Your Lordship, today I am only pressing the.
No, interim bail, because the other problem is that this disability is long since.
No, Your Lordship,
You started accepting money and taking away the duping people while being disabled. It's not that while in custody this has developed. You must understand the condition for. So I have to obtain the report from the health condition.
I admit, Your Lordship, but the health is.
The learned counsel for the petitioner has moved.
I beg your
IA
pardon,
621 of 2024. Listen to the order. Don't be impatient. 621 of 2024, praying for interim bail. The copy of the IA has been served on the question has been served on the learned AC, who shall obtain instruction from the jail authorities as well as the doctor regarding the present health condition of the petitioner and the treatment administered to him by the next date, list in the week commencing 18/6/2024 oblique when moved by the petitioner. Yes, what you are saying?
Your Lordship may grant me liberty to move it before the vacation bench, Your Lordship.
No.
Your Lordship, the petitioner.
Don't go on a fishing expedition.
No, Your Lordship, the petitioner, I am submitting.
If you are happy for rejection, I'll observe that. Though I directed for obtaining a health report of the petitioner, so you are.
Your pardon, Your
You are seeking adjournment and the petition is rejected.
I beg your pardon, Your Lordship. I'm only submitting a medical report, Your Lordship.
No.
The petitioner used
that should be supported by affidavit on record. Don't convert into a shop, kirana shop that you throw on papers. That you should have been responsible enough to support by affidavit. That could have been served on them, but prevented from enclosing the medical report to the IA.
Your Lordship, we obtained it at a later stage.
So court can't be held.
I bow down, Your Lordship.
You filed that affidavit.
I filed a memo. I'll file it.
Whatever you filed.
Your Lordship,
you file it and serve it on him.
A date may be fixed.
And here there is no provision of filing because I can't take it up on record. This is a paperless code. And bails are taken up paperless. No physical filing. You should have filed with the affidavit, served a copy on them. So this order takes care of everything because they are already obtaining that. In response to your petition, they will be obtaining the medical report.
Oblige, Your Lordship may fix up a date, Your Lordship.
Already fixed.
Week commencing 18.
Much obliged.
Already fixed on in the week commencing 18/6 oblique when moved.
Much obliged.
The learned AC shall also obtain up-to-date instruction, case diary, status of investigation. Shall I record? But I don't think you don't sound very confident because that creates problem.
It is there in the FIR, Your Lordship.
Not FIR, you do not know what is the amount and how many persons are involved. That I have been repeatedly asking you. If you have that particular instruction, file that affidavit on behalf of the petitioner.
Your Lordship.
Bring that on record. That will be served on them. Let them respond. Let's shall obtain so and so. Like that. You obtain up-to-date case diary instruction?
Yes.
Yes. Yes.
Mr. Your Lordship.
This is Belgium.
My Lord, I am supplying the order sheets. I got the order sheets yesterday.
That is your submission.
My Lord,
default hela? First default kebe hela?
First default NBWC on last order, Your Lordship, in the order sheet.
2004
21/1/2024. Accused persons are absent.
2002.
There is 17 number order.
ନାଇଁ ନାଇଁ ଦୁଇ ଦେଖନ୍ତୁ ସେଟା ଆପଣ କୁଆଡେ ପଢୁଛନ୍ତି ଭଗବାନ ଆପଣ ପେଜ ମାର୍କ ନାହିଁ ଥାର୍ଡ ପେଜ ରେ ଦେଖନ୍ତୁ ଅର୍ଡର ନମ୍ବର 13
ଆଜ୍ଞା 22/3/2 accused persons are absent issue summon to the accused
ହେଲା ତାପରେ ଦେଖନ୍ତୁ
fixing 23
SR not back ଅଛି ଆଜ୍ଞା କହିବେ ନା SR not back ଆଉ
ଆଜ୍ଞା SR not back ହେଇଗଲା
ଆପଣ କ୍ଷୀରୋଦ ଦେଓ ନା କିଏ ଆପଣ
ନାଇଁ ମୁଁ
କେତେ ଟଙ୍କା ଦେବେ
as your lordship
ନାଇଁ ନାଇଁ
as your lord
ଆପଣଙ୍କ ବର୍ଷକୁ 5 ଟଙ୍କା ତ ବହୁତ ହେଇଯିବ
20 ବର୍ଷ
ହେଇଯିବ ଇଏ କେତେ ଜଣ ପିଲା ଅଛନ୍ତି
2 ଜଣ accused ଥିଲେ ଇଏ ଗୋଟେ ଅଛି ମାନେ one accused ବି
ବାର ଆସୋସିଏସନ କୁ କେତେ ଟଙ୍କା ଦେବେ କୁହନ୍ତୁ
as your lordship bill proper
Mr. Prakash Kumar Mishra for the petitioner you should have ଆପଣ ଯଦି କି order sheet ଟା ଥାନ୍ତା ଆପଣଙ୍କ ହାତରେ it should have been much more easier for you you would have been convinced for the petitioner Mr. Karunakara Das AC for the state on 4/6/2024 the following order was passed. The learned counsel for the petitioner referring to the said order submits that he has obtained the order sheet in GR 831 of 2000 pending in the court of the learned justice Hon'Ble.
My lord, now it is pending before JMFC Warrant after opening of new
just a second justice Hon'Ble comma now नहीं सेटा कौन लिखले अनुगुण ठीक अच्छे अनुगुण from 16th December 2000 till 21 January 2004 हाँ 21/1/2004 it is submitted that thereafter the matter has been in the file of Transport 2 and in the file of
JMFC
bond part. Stop. The learned ASC referring to the failure of the petitioner to respond to the warrant issued by the learned court in season of the matters submits that the petition is liable to be rejected. Para. This court is of the view that the order passed by the learned court in season of the matter is just and proper, is not supposed to be interfered with. Stop. Para. However, it is directed that if the petitioner surrenders within 3 weeks.
My lord, I am in custody, my lord.
Acha, the petitioner shall tell first paragraph ta apno dekhi lekhibe
by virtue of LBW I am
apon joda cut and paste karibeni ki achi seta 4/6 order re achi already
by the
for NDPS ki arrest hichunti the petitioner if the petitioner shall move for bail before the allotted court in season of the matter within a week kebe move karibe
it to order hele mu bail bond debi seti
se jaha bi korantu apana kete din korbre move karibe mo pachauchi apana bail bond no debi paranti fail bi kari bitar rahi paranti kete din bitar move kari paribe
within a week
na 2 weeks
within a week
within 2 weeks the learned court shall release the petitioner on bail subject to such terms and conditions that would be deemed fit and proper by the learned court. Para. This order is subject to the petitioner depositing a cost of rupees 1,000 in the Orissa High Court
Bar Association
welfare fund within
in course of the day.
Within 3 working days. Within 3 working days, the receipt of the such deposit shall be filed before in the registry of the court, and copy shall be also produced before the learned court in season of the matter. Disposed of accordingly. Urgent certificate copy as per rules. Yes.
Obliged.
Eta nahi jante.
The part of the record code. ସେଇଟା part of the record ହେଇଯିବ।
Certified copy ଆଣିଛନ୍ତି ନା କଣ ଦରକାର ହବ ସେଠି? ଆପଣ ଗୋଟେ କପି ଦେଇ ଦଉନାହାନ୍ତି?
ନା ଆଉ ଦରକାର ନାହିଁ।
ଦରକାର ନାହିଁ ତ?
ନାଇଁ।
ତା ତଳେ ଲେଖନ୍ତୁ the copy of the orders as referred above, certified copy of the orders as referred above, produced in the court today shall be kept on record. Scan copy be updated.
Due to issuance of NBW in a 130 case and had provided
order file ନାହିଁ ଦେଖନ୍ତୁ ମିଶ୍ର order ଆଣିକି ଦେଖିକି ଦେଖେଇଲେ କୋର୍ଟରେ
ମୁଁ ଆଜ୍ଞା ଗୋଟେ ଦିନ
ଅଧଘଣ୍ଟା ନେଇଗଲେ 5:15 ହେଇଗଲା
କାଲି ନୟାଗଡ଼କୁ ଆଜ୍ଞା ଗୋଟେ ଦିନ ନେଇକି ଆସିଛି।
ଆପଣ କହିଥିଲେ ଆପଣ ଆହୁରି ଆଗୁଆ ଅଛନ୍ତି।
Last page
କମ ବାଟ ବୁଝୁ
throughout 317 petition द्वारा represent ହେଇଛି after going on bail. On 18/9/2023 a new advocate was engaged. Perhaps he is not aware of criminal law. So
last page of that order certified copy ये से ଗୋଟେ ଭୁଲ କରିଛନ୍ତି ବୋଲି rule issue ହେଇଛି।
28 लास्ट जोड़ा टाइम पिटिशन देखिए आଜ୍ଞା ଦେଖନ୍ତୁ ସେ ପ୍ଲାଣ୍ଟିଫ ଡିଫେଣ୍ଡାଣ୍ଟ ଲେଖିଛନ୍ତି ଫର ଏଭିଡେନ୍ସ ଏଇ ପିଟିशन ରେ 317 ପିଟିशन ଦିଆ ଯାଇନି। So that is why NBW was issued for the first time.
ଦଶରଥ ସେ ଯୋଉ ଅର୍ଡରଟା କୋଡେ ହେଲା
ଅର୍ଡରଟା କୋଡେ ହେଲା କି ଜାଣିବା ତାହେଲେ ଟିକେ ପାସ୍ ଓଭର କରିଦିଅନ୍ତୁ ଆମର ରେକର୍ଡ ଅପଡେଟ୍ ନାହିଁ just give me some time. Yes please next
36
Mr. Anupam Das for the petitioner, Mr. Karunakar Das for the ASC for the state.
May it please, Your Lordship.
Yes.
The petitioner, my lords, is in custody since 11th of November 2023.
376 to N.
376.
So notice दरकार?
No. नहीं.
Poxo अच्छी की तरह?
नहीं, Poxo नहीं, my lords. Both are married. My lords, if your lordship, though I have not annexed the FIR, my lords, the rejection order, if your lordship sees also.
First time पे असला?
First time.
Should be.
The petition under section 439 of the CRPC has been filed by the petitioner. In jail custody in connection with so and so complete कर दिए तो it is submitted by the learned counsel for the petitioner that the petitioner is in custody since
11/11/2023
11th of November 2023 and considering the 23 considering the period of incarceration and the nature of allegations the petitioner is entitled to bail as in the meanwhile final prosecution report has been submitted.
The final charge sheet has been filed.
And, as in the meanwhile the final prosecution report has been submitted. The learned ASC in response submits that he shall obtain up-to-date case diary instructions, status of trial by the next state as prayed for list in the week commencing 1/7/2024 public moved by the petitioner.
Lordship, may kindly, my lord, sir, gracious enough to give a particular date, my lord, if that is possible, my lord.
No, that doesn't. You see, I have not. I don't have roster power. That's a long way to go. And the other part is that I'm not supposed to distort the list of other benches. So that is how I'm giving you liberty to move. You see, if I fix a date, you cannot move. It is not listed, then your prayer is frustrated. If I'm giving you liberty, you can move the bench. In the week commencing केबे लिखिले? 1/7 before the assigned bench. Public moved by the petitioner. Assigned bench यदि अपन को move कले allow कले अपन आगुरी भी list करी परिवे. Yes.
37
May I please, Your Lordship?
Yes.
Well, offense under section 20(IC) of NDPS Act. Custody since 11th April 24.
कितने किलो?
My lord, 43. My lord, from my possession, 25.720 kg. And Coac is already released on bail, my lord.
By the 15 January 30 ଆସିବା କଥା ନୁହଁ।
My lord?
Coac जो released ହେଇଛନ୍ତି ତାହେଲେ ଏଟା ସେ bench को ଯିବ।
Today, by Honorable Justice S.K. Panigai, my lord.
তখন ফার্স্ট সে ডিল করছে
ହବନି ତାହେଲେ ପ୍ରଧାନ ଜାନି ପଢିଲେଣି
ନାଇଁ ମ୍ୟାମ୍
ଆଉ କଣ ଆପଣ ଆଜ୍ଞା କରୁଛୁ ପ୍ରଧାନୀ ଜାନି କୁଶଦୁର୍ଗା ପଢିବେ ନା ଆଉ
ଆଜ୍ଞା
ଯିଏ ଫାର୍ଷ୍ଟ ଡିଲ୍ କରିଥିବେ ସେଇଠିକି ଯିବ
Mr. Jagannath Gochak for the petitioner, Mr. Orupanand, Mr. Karunakara Das for the AC for the state, the learned counsel for the petitioner submits that the co-accused has been released on bail by a coordinated bench by order dated
today, my lord.
जी कहते 6 तारीख 6/6/2024 in BLOPL number
5652
of 2024 in view of the standing order number 2 dated May of 2023. The matter may be listed before the appropriate bench for consideration. Registry to do the needful. Yes, the matter of luck. ସେଟା କିଛି ଆପଣଙ୍କର କଣ କଣ କରିପାରିବେ ସେ ୟାଙ୍କର ସେ ଯାଇଥିଲେ ରିଲିଜ ହେଇଯାଇଥାନ୍ତେ so
obviously
yes
38 may be called CD may be called for 302
please your lordship.
ସେ ଯୋଉଟାରେ ଯୋଉଟା 37 ଲେଖିବେ the learned AC shall obtain up to date instruction case diary past allegations of criminal activity, comma, if any, in the meantime. You obtain the instruction
Yes.
because maybe it will be again urgent for that. Suppose
today I'll write the letter.
Yes, yes.
My lord, I am
Mr. Biswajit Prasad for the petitioner. Petitioner, Mr. Karunakara Das, AAC for the state. The petition under section 438 of the CRPC has been filed. 439 of the CRPC has been filed. ଆପଣ ମାନେ ଏତେ କଥା କହୁଛନ୍ତି ମୁଁ ଏପଟ ସେପଟ କରେ କଣ ଅସୁବିଧା ଅଛି 439 of the CRPC ଆପଣଙ୍କର ଅଛି ରାଇଟ୍ ଅଫ ଇକ୍ୱାଲିଟି ନାହିଁ
ଲେଟ୍ ହେଲେ ସେ ହବ ସବୁ ଭୁଲ ଭାଲ ତାଠୁ ପ୍ରେସର ହବ
43 ସେ କରେକ୍ସନ ହେଇଯିବ ସେଟା ହେଇଯିବ ଥ୍ୟାଙ୍କ ୟୁ 439 of the CRPC has been filed by the petitioner who is in jail custody in connection with Bada Bazar PS case number 8 purata likhile the learned AC in response to the prayer for bail submits that he may be accommodated to obtain up-to-date instructions, case diary, autopsy report and criminal antecedents by the next date. List in the week commencing AK na 8
reopening I pray that's
एक 7/2024 oblique moved by the petitioner. The case diary, up-to-date case diary instructions will be obtained by the next date.
I should pray, my lord, it's the status of the stage of proceeding, my lord.
ସେଟା ଆପଣ ନେବେ ନା ସବୁ ଜିନିଷ ଠିକ ଅଛି ଲେଖି ଦିଅନ୍ତୁ stage of trial ଆପଣଙ୍କ ପାଖରେ ଯଦି କିଛି substantial evidence ଅଛି ସେଟା you bring those depositions of the prosecution witnesses ତାକୁ ଦିଅନ୍ତୁ ସେ ଦେଖିବେ
I have to verify with the
କେତେ ଜଣ ହେଲେଣି ଧରନ୍ତୁ ଦିଟା witness ଅଛନ୍ତି ଆପଣ ଗୋଟାଙ୍କର ଦେଲେ ସେଟା ଆପଣଙ୍କ ଫେଭରରେ ସେ ଶିଶୁଟି ଗୋଟେ ଆଣିଲେ ଆପଣଙ୍କ ଏଗେନ୍ଷ୍ଟ ଲାଭ କଣ ହେଲା ତାହେଲେ you have to be sure particular. Yes, next.
Please,
yes ତାକୁ ପିନ୍ କଲେ
I pray for adjournment.
Mr. Suchit Kumar Naik for the petitioner, Mr. KK Das for the SK Naik for the petitioner, KK Das for the AC for the state, learned counsel for the petitioner seeks accommodation to advance arguments as paid for list after vacation. Being moved by the when moved by the petitioner. Yes. Mr. Amlan Shakti Paul for the petitioner, Mr. KK Das AC for the state. Yes, Mr. Paul.
Maybe.
My lord, while the petitioner is in custody in another case, my lord, it's a unknown case, my lord, and remanded in this case, my lord. Meantime, my lord, charge sheet has been submitted in this case, and the petitioner has been remanded in this case, my lord, 14/3/2024, my lord.
Sir, case to bill option.
Bill, I am submitting the copy.
Sir, that diuntu.
Charge sheet has been submitted.
The petition under section 439 of the CRPC has been filed by the petitioner who is in jail custody in connection with PS case number 70 of 2024 corresponding to C.T. case number 228 of 2024 pending in the court of law at JMFC Roman capital 1. The learned AAC in response to the prayer for bail submits that he is maybe granted, he may be accommodated to obtain up-to-date case diary, status of investigation, oblique trial by the next state as paid for list in the week commencing. When do you want? एक है ना आठ है केबे एक साथ
24
24 में बहुत मैटर है जुआ. I do not know how many matters are to in the week commencing एक के साथ 2024 before the assigned bench. तापर लेखन तो oblique when moved by the petitioner. When moved by the petitioner. Yes.
My lord, item 45. Another my lord remand case of the present petitioner, my lord.
45 same order करते. FIR number ये number समान.
Yes, my lord.
Remand case को चुनता है कहेंगी.
No, arrested in another case, my lord, and
remanded in this case. ATM
PS case अलगा होता है ना.
Yes, my lord.
तल सेटा कल past paragraph PS case GR number और change करते हैं. Appearance टा 45 रे क्या आपण? 45 रे आपण ना कि? Same appearance.
कितना 49 45.
Yes. Mr. Saroj Kumar Pari for the petitioner, Mr. Karunakar Das ASC for the state. Yes, Mr. Pari.
Your Lordship, petitioner is in custody.
Yes.
Since 23/24, FIR is against unknown persons. Basing on the confessional statement of one of the co-accused petitioners has been arraigned. And the fact remains, Lordship.
Past allegations of criminal activity affidavit don't
not there any Lordship. Today there were two other bail appeals listed before a coordinated bench of this honorable court. Same affair. Let the matter be tagged with those applications.
No, that I cannot direct.
Okay, Lords.
You have to move. Allow na pending achi.
Pending achi.
How can I direct? So, Saroj Kumar Pari, the learned counsel for the petitioner's first paragraph लिखिले petition under section 439. Second, in response to the prayer for bail, the learned ASC submits that he may be accommodated to obtain up-to-date case diary instructions, past allegations of criminal activity against the petitioner. As paid for list in the week commencing A के साथ तो 2024 सेटा केउ जाई जानछन दी
not dated sir.
Except 2024 to be listed before the assigned bench oblique moved by the petitioner.
Lords.
The learned ASC shall obtain so and so so and so.
Lords.
Yes.
Nice.
Okay, so I may be permitted to submit
Yes.
the case. Mullahs, I'm appearing through VC Mullahs. I may be permitted to submit the case on behalf of Counsel Divya Prakash Mishra Mullahs.
M.M. Ansari.
Yes, my name is M.M. Ansari.
Mr. M.M. Ansari. Sorry?
I may be permitted to mention on behalf of Counsel Divya Prakash Mishra.
On behalf of DP Mishra.
Yes, Mullahs.
For the petitioner, Mr. Karunakar Das ASC for the state.
Actually, Mullahs,
the learned counsel for the petitioner being present in VC addresses arguments. Yes.
Mullahs, Shri DP Mishra is had some medical issues, so he will not be able to appear before Lordship to conduct his case. So I seek adjournment on his behalf, Mullahs.
The prayer for adjournment is made on behalf of the learned counsel for the petitioner due to personal difficulty, as prayed for list after vacation. When moved by the petitioner. When moved by the petitioner. Yes.
May I be allowed to submit one more thing, Mullahs?
Yes, please.
Item number 49 for the same council, my lords.
49 ରୁ same adjournment ହବ.
Yes, my lords. Much obliged, my lords. Much obliged.
42 equal to 49. 49 ରେ state council କିଏ ଆପଣ ଅଛନ୍ତି? Yes. 49 ରେ state council Mr. AC PK Mahanti, Prasanna Kumar Mahanti. Yes.
Grateful, my lords.
Yes.
30302 CD request.
Mahanti, none appears for the petitioner when the matter is called. To grant further opportunity, list after vacation, oblique moved by the petitioner.
44.
Mr. PK Sahu.
Yes, ma'am.
For the petitioner, Mr. KK Das for the Karunakar Das AC for the state. Yes, Mr. Sahu.
Under accusation under section 467 and 420 of IPC.
Yes.
Here, my lord, I am in jail since 5th April 2024.
Total amount kete?
Amount, my lord, dujon
85 lakhs 99.
85 lakhs, two accused persons and 2 victims. And as per the allegation, I was serving in a company for the purpose of
the petition under section 439 of the CRPC has been filed by the petitioner who is in jail custody in connection with so and so, so and so. Para 2, in response to the prayer for bail, the Lord AC seeks accommodation to obtain up-to-date case diary instructions and as well as past allegations of criminal activity, if any, against the petitioner. Para, accordingly, the matter shall be listed in the week commencing
after vacation time.
After 8th. को week रे? First week na 8th week?
First week.
माने 1 जुलाई ना 8 जुलाई?
1 July.
In the week commencing 1/7/2024, the Lord AC shall obtain so and so, so and so. Yes. Next, please. 45, Mr. Pal.
45 जाइची.
45 से adjourn कले. नहीं, Mr. Pal mention करते ले. Yes. 46, Mr. Mahato.
May I please, my lord?
Mr.
Lord, here the offense under section 392 of IPC. Allegation is that he has taken an action.
Mr. R. Mahato. Mr. R. Mahato for the petitioner, Mr. KK Das, AC for the state. The petition under section 439 of the CRPC has been filed by the petitioner who is in jail custody in connection with so and so, so and so. Yes, what is your submission, Mr. Mahato?
My lord, it is an attempt, your lordship. Lordship, may kindly peruse the FIR.
So, past allegations nahi kochundi na kon?
Past allegations gote achi similar offense re.
Successful agent seta.
Na successful.
Seta actual offense, seta attempt.
Seta bi successful haini. Same thing.
Sabule attempt kori fail marchum.
A nua korchi ega dhara podi jaychi. Lordship, may kindly peruse the allegation.
Eta ki mobile ta seize jaychi. Tare rejection or page 12 lordship.
से completion of offense हो तो मोबाइल टा चाली जी आगे तक कुछ कया कथा.
He was FIR named. Lordship, may kindly peruse the allegation. When he has
से आनंद तो
a mobile has already been recovered, man.
से instruction आनंद तो कारण अन्य मानु कहाँ को भी दिया हो नहीं तेरे से instruction पे रहूची so पेटा first time ना आगुर तो आसी नहीं.
Tribal by magistrate था lord.
ठीक अच्छी. But the problem is that the repetitive offender has this problem. Agur belle jaychenti na nahi? Thila condition je he shall indulge in similar matters, similar type of offenses.
No, sir. Then lordship may impose condition that he will appear in the police station on each and every.
Police station I do not know. In the magistrate je tribe jo magistrate je se to condition grant karibe. But I have to see that the person who has been granted liberty is misutilizing or utilizing the liberty. And there can be a condition that say Chabishanda Thanare Bosive, Seta, that I don't know. But that those conditions I am not imposing. If fatal say antecedent anantu.
Antecedent gote achi aga.
but let us see. Let him be there for some time.
That was also reflected in the rejection order. Kote hi ଅଛି.
Let us see. କେବେ ଗଲେ କି ସେ କଷ୍ଟଡି?
କଷ୍ଟଡି 15/5/2024.
ଲାଷ୍ଟ ଟାଇମ କେତେ ଦିନ ରହିଥିଲେ ଗଲା ମ୍ୟାଟରଟାରେ?
ଗଲା ମ୍ୟାଟରରେ ବି ମାସେ ଖଣ୍ଡେ ରହିଥିଲେ.
Yes.
That was the only three.
So why he is safe? So let him get instruction.
379 ଟା ଥିଲା ସେଟା. 379 ଥିଲା.
Whatever, I don't know, but you see, whenever there is a misutilization of the utility liberty granted by the court, that creates a doubt in the mind of the court that what the court is doing, because there are two competing claims: one, so somebody's liberty, and the society's cry for justice. Upon छोट छोटा ये करी कि जितने थोड़ा repeat करीबे, is it that it should be granted leniency should be shown? ଆପଣଙ୍କର ଏଟା କେସ୍ ଡାଇରୀ କିଛି ନାହିଁ ଇନଷ୍ଟ୍ରକ୍ସନ
ନାହିଁ
ଆଣନ୍ତୁ ତାହେଲେ ମିଷ୍ଟର ଫାର୍ଷ୍ଟ ପାରା ଲେଖିଲେ ତାପରେ ସେକେଣ୍ଡ ପାରା ଲେଖନ୍ତୁ ଦ ଲର୍ନେଡ୍ ଏସି ଇନ୍ ରେସ୍ପନ୍ସ ଟୁ ଦ ପ୍ରେୟର ଫର ବେଲ୍ ସବମିଟ୍ସ ଦ୍ୟାଟ୍ ହି ମେ ବି ଆକୋମୋଡେଟେଡ୍ ଟୁ obtain up to date instructions case diary past allegations of criminal activity against the petitioner comma if any para according to the matter be listed in the week commencing 1st July एक साथ 24 तो बहुत मैटर है जो एक साथ 2024 तो एसी शैल ऑब्टेन so and so yes
47
yes
may please my lords
Mr. Praharaj
my lords
you are Mr. Praharaj Mr. Prabhat Kumar P.K. Praharaj for the petitioner Mr. Karunakara Das ASC for the state. Yes.
The allegations are under section 20B2C of the
antecedent of Anand. Antecedent. First paragraph saman rahela, second paragraph saman. List in the week commencing 1 and 8 hai.
1
in the week commencing 1 ke sath 2024
just I am
the AC shall obtain instructions the pura repeat kar debe. Case diary, criminal antecedents if any. Yes. Up to date case diary, status of investigation, criminal antecedents.
Just I am reading the second paragraph of the PR. The present petition is no way connected with the allegations leveled against the petitioner.
But we have to that should be a record.
He was also not in the car. He was waiting.
That is your submission. That is your submission. I am just simply not making your submission to save time. Because it's of no use unless I get it on record. So then there is no point. I cannot consider it also.
Neither kichhi allegation nahi in the PR.
That is dangerous in NDPS case. In NDPS case, usually the persons who are courier, they are being caught.
No.
Mastermind is never caught.
He was waiting.
So we have to consider that while submitting in case of an NDPS case. Why they will arrest?
Because they are 90% petitioner to be an witness.
You see, in jail visits, you will find 90% of people, including ladies, they are only carrying the carriers. No one, the mastermind sitting and operating the syndicate is never apprehended.
See,
so that was because somebody is not named in the FIR. FIR ki name hondi, jahan ko dhara huye. So they don't disclose.
See the Honda Amaze car. The excise people detain the car. In car, 2 persons were there. It is also in the pair.
They named somebody mastermind.
No, nothing is there.
So your so तापर से कलेक्टर जेल को कहीं की गले?
ताकू कहले तू witness सभा को he refused. He was waiting for a bus in Ambapalli Chakka. That is the cause. Let the case.
NDPS ने witness को डॉक्का जाएनी. अपन तो आपनकर vast trial court practice अछि NDPS ने ताकर थागे witness जे
one witness must be there.
कहा को डॉक्का जाएनी जे बस छक्करे छिड़ाई थिवे बुझ पड़नती in NDPS matters they don't take ask somebody unknown who is standing on the कोई चौराहा पे खड़ा है उसको नहीं बुलाते हैं
तार
शेर ताकर लोग पूछंती के हेबे don't presume that the court is so naive that he will believe you छक्करे छिड़ाई थे डाकिला के आ विटनेस सब सेमती होंती नहीं है
ना पीआर रे भी ताका नाम भी अच्छी
अपन जानछन आजी गोटे मैटर रे से जो बेलबन फर्स्ट बेलबन मिस्टर प्रधान आर्ग्यू करथिले so then setire the persons who usually furnish bail bond they have been arrested for furnishing fake bail bond etire they don't take chance आपण छकरे छिड़े चनी बस रे पळेबे आपण नेबे तो केस गला ताले it is such a stringent technical offense टिके एपट से उठेले गला ତେଣୁ ସିଏ ତାଙ୍କର ଲୋକ ଅଛନ୍ତି କିଏ ସାକ୍ଷୀ ହେବେ ସିଜର ୱିଟନେସ୍ ତ ସିଜର ୱିଟନେସ୍ କରିବେ ଆପଣ ଛକରେ ଛିଡା ହେଇଥିବେ ଯାହାକୁ
ସେଥିପାଇଁ ତାଙ୍କର ସିଲ୍ଟା ଦେବେ ତାକୁ ହ୍ୟାଣ୍ଡ ଓଭର ଦେବେ କରିବେ ସିଲ୍ଟାକୁ ଦି ପର୍ଟିକୁଲାର ପର୍ସନ ୟାକୁ କହିଲେ ଇଏ ମନା କଲା because he is a man of Konark. He is waiting for a bus at 4 o'clock in the morning. That is the time.
That is not plausible, Mr. Paraj. Yes, next 48. Mr. Kanun go.
48. The petitioner, he has been languishing in jail for more than 5 months. And meanwhile, in this present case, charge sheet has already been submitted. And the learned magistrate, she has already taken the cognizance in this matter. So, there is no further investigation to be required in this case. So, let him be released on bail as because charge sheet against him, it has been submitted. I have already annexed the charge sheet.
Antecedent?
One antecedent, it was there.
Have you filed affidavit?
He has been already released on bail by this.
That is not binding. If it is the same FIR, then it has to go to that bench.
No, it is another case.
So if it is another case, that shows that is against you. So you file that affidavit?
I'll file it tomorrow.
No, tomorrow it's not possible. So they let them obtain a case there and instruction.
This is a case of fundamental rights of an individual.
To cheat.
Not to cheat. He has been implicated. Until unless he has been the trial is over.
You are PhD in law.
Yes.
So no fundamental right to cheat.
No, but this
I can record that also. And fundamental of right to cheat and to be in custody.
I am coming to that.
You see,
every individual
fundamental right of what?
Fundamental rights. It is the right.
Which fundamental right? Not to be in jail after committing crime.
No, but he has been personally implicated.
Sir, I'm not a trial judge. I'm not a magistrate.
No, I am coming to that.
Even I cannot write, even being a High Court judge, can I write that since the petitioner is innocent, he will be released on bail?
No, I am not pleading for that.
But you are saying that his fundamental right to what has been violated?
Human rights has been violated.
Human right to cheat and behind jail. That kind of right is not there.
I am coming to the FIR contention. Please, I have a glance.
Sir, FIR is, in fact, I was discussing. FIR is not only sets the criminal law in motion. Beyond that, it has no evidentiary value.
The criminal law of this country, it is very crystal clear. Whatever it is there enshrined in the Constitution, I am pleading for that.
No, which article of the Constitution? Fundamental right to cheat.
Article 21.
Article 21. I can record that. I'll also defer that. There is no right to cheat and behind
the. This is not the opera or theatre. I am acting. I am pleading for my client.
Yes, you are pleading for your client. The court has to interact with you, Dr. Kanungo. I can record that. The right of somebody, you see, curtailed right, your right to life is curtailed till you indulge in criminality.
Investigating agency will
say that a person doesn't have a right not to be cheated.
Investigating agency will pick someone and put behind the bar.
Could be, but
they are in the Constitution.
But that don't ask me this question. I have not done that. I have not asked you the question.
Is it there in the Constitution?
Sir, don't ask me question. The learned counsel for the petitioner, Dr. Sushant asked the court that it is there in the Constitution.
No, you told
that's a question. No, I never tell anything. I'm interacting.
Rights is
that this is not a drawing room discussion. This is not a drawing room discussion.
Oh, that is fine, sir.
Sir, you are saying that submits that there is it there in the Constitution that the investigating agency will pick up someone and put him behind bar? In considered opinion of this court, the putting up such questions to the court.
No, I am not
beyond scope of the present deliberation.
Putting this question.
Yes. Please carry on. Please carry on. It is further submitted that the petitioner is innocent, though.
And charge sheet already it has been
and the charge sheet has been submitted.
Matter of 60,000.
In the rejection order, that is BL APL number 158 of 2024, at paragraph
4.
Paragraph 5, page 26 of the brief. it is indicated that the petitioner is involved in Tirtol PS case number 45 of 2024 under section 417 of 419 oblique 420 oblique 465 purada likhibe, and Balikuda PS case number 416 of 2023 under section 294 of 323 oblique 420 of 506. It is also noted by the learned Additional Session Judge Jagat Singhpur, referring to the above FIRs, that the petitioner has the past allegations of criminal activity of similar nature against him. It is submitted by the learned counsel for the petitioner that the petitioner has been granted bail in
BLP number. Sir, BLP number.
Order Bill Appeal number 1476 of 2024, while in custody, in connection with GR number 65 of 2024, arising out of Tirtol PS case number 45 of 2024, pending in the court of learned JMFC Tirtol. Jaldi hi jo chiki. Para. Apparently, at present, there are 3 cases against the petitioner, out of which coordinate bench of this court has granted him bail by order dated 13/5/2024 in BL appeal number 1476 of 2024. Copy of the said bail order is kept on record. The learned AC, responding to the prayer for bails, seeks accommodation to obtain up-to-date instruction, case diary, status of investigation, as well as past allegations of criminal proclivity against the petitioner, apart from the above cases, list in the week commencing 1st of July.
Millard, 24th June. Because his mother is seriously ill. His mother is seriously ill.
So the interim bill file karthante now. So the interim bill file kariyo. So that in the week commencing 24 June 2024, the AC shall obtain the details as indicated above. Yes. Our subject कौन थी like PhD रे?
National Human Rights Commission in India and South Africa, a comparative analysis from Delhi University.
Campus Law Center.
Law Center.
की constitutional law की पढ़ेले?
Professor J.K. Kaur.
J.K. na J.L.
There are 2 J. One is Jawaharlal Kaur and one other is Jawaharlal Kaur.
ଆପଣ को JL ପଢିଥିଲେ?
Millard.
ତାଙ୍କ ଭାଇ ହେଲେ କିଏ କଣ?
Millard.
Coincidentally ସେ ମତେ ତ ଓଡା ପଢେଇ ନଥିଲେ? JL ଯୋଡା ମତେ ଆପଣ ପଢେଇଛନ୍ତି? When he was joined CLC, he taught also constitutional law along with MP Singh, Professor Irabi and Parmanand Singh.
I was the resident of Jubilee Hall.
Achha.
My
Jubilee Hall, which floor?
2nd floor.
That could be the reason. Though I was taught by JL Cole when he was leader, but I stayed in 3rd floor and left Jubilee Hall. There is no fundamental, so you should not make, you should be conscious what you are submitting. And the reason being that it is being recorded and seen by the entire world.
No, I have all humble submission.
No. So that's not there. Because people start, because of these things, you get a troll. You get a troll that people, even have you marked that these are in social media, some judge sleeping and something. This is all.
Yeah. And I was taught also Honorable CJ D.Y. Chandrachud. At that point of time, he was taking classes.
Visiting faculty?
Visiting faculty.
That I don't know. He is a student, I know, the batchmate of Mr. Nanda, A.K. Nanda.
Yeah.
Yes. You submitted PhD under the Dr. Call.
No, but it was Professor Rekha Saxena.
Saxena. Rekha Saxena. See, I don't know.
And Professor Mohanty was my co-guide. Professor Manoranjan.
Manoranjan Mohanty, political scientist.
Political scientist. He's my cousin.
Yes, next. Yes. Password.
Password 35.
Yes.
The petitioner were arrested due to issuance of imbue. Earlier, they have been bailed out on.
You are Mr. At item 35 lekhantu. So Mrityunjay Banerjee for the କୋଡ ଟା ରେଫର କରୁଛନ୍ତି ନା ଆପଣଙ୍କ କପି ନାହିଁ 28/9/2023
my lord. What happened? Well, after
Mr. Das, you are saying that 28/9 on the first instance the NBW has been issued.
Yes, ma'am. On 18/8 another council was separate council was engaged. On 28/9 he has given a petition saying that defendant and सिविल वाला करते क्रिमिनल केस इतने भूलभाल हो जाए
भूलभाल से प्रथम 18 रे गोटे मास समय मागिले तापर तांको 10 दिन समय दिया हला से सेतर गोटे पिटिशन देले टाइम फॉर एविडेंस इज दैट टाइम फॉर चार्ज ड्यू टू लैप्सेस ऑफ द एडवोकेट एंड इनविटेबल वाज इशूड एट फर्स्ट इंस्टेंस
So Mrityunjay M. Banerjee for the petitioner. Mr. M. Banerjee for the petitioner, Mr. K.K. Das, AC for the state. The learned counsel for the petitioner refers to the certified copy of the orders passed in 1cc case number 15 of 2022 in the file of the learned STJ Nayagar. That is orders stated 22/3/2022. Up to 9/4/2024 to show that NBW was issued by order dated 28/9/2023, which apparently was not necessary. As last chance was granted on 18/9/2023 and the petitioner was represented through a different counsel on
18/9
on 18/9/2023.
And he seeks for time to 1 month.
Petition order.
Counsel for the petitioner also submits that the time petition was filed on 18/9/2023 by the earlier counsel, Vairaj. On 28/9/2023, due to change of counsel, the said fact could not be brought to the notice of the learned court in season of the matter.
18/9/2023, the separate counsel was one press counsel appear kale.
Exactly से डाकी चिमु.
तापर 28/9 रे से appear kale नि ये हेला.
नहीं से कहउछन्ती से सेटा कोन मु कंडा कि से कहउछन्ती काउंसिल बदली गले जे जानि पालेनी
18 रे
so why you are putting words to his mouth maybe सेटा what so सेtra why should the court interpret in that way से कहले जे वकील बदली गले जहां भी से कहले से कोन
मो टाइम पिटिशन जोड़ा जाकर भी आने
ठीक अछि कोन लिखले could not be brought to the so I have dictated on 18/9 the time petition was filed which could not be brought to the notice of the court on 28/9 as due to change of counsel So on 18-9, the time petition was rejected. But that was the first occasion when he paid for time.
No, 18-9, 1 second. 18-9, yes, fresh counsel appeared and filed a time petition. It was allowed till 28-9-2023.
Whatever it may be, say 28-9 रे केही वकील नथिले as it seems.
ना फाइल हाजिरा कले
ଥିଲେ
सेटा
advocate for complaint
अरे से वकील के वकील को से वकील नथिले ବୋଲି से कहउछन से कहउछन से वकील नथिले. The learned ASC referring to the orders passed by the learned court in season opposes the prayer for bail. Para. Having had learned counsel for the parties, it is directed if the petitioner moves for bail before the learned court in season of the matter, the same shall be
petitioner in custody.
से आपण bail move करिवेनी
आय
आउ ताले आज कोन हेछि मु बुझी पानी समस्त बेले बेले very strange kind of ये fundamental right जो inspired है कि fundamental right to be in custody किछि नाही not to be in custody. आंकर कौन भूल है जो जज को कौन भूल कले
पढ़ी ना ज्ञान दिल्ली यूनिवर्सिटी
नहीं नहीं सेठी जहां एठी से यार पूरी इज मच बेटर तो कौन अछि वही तो घरी पढ़िया का तेरे कौन अछि
पढ़िया
the petitioner in custody shall move the अपन problem होछि कि बहुत समय नष्ट होछि. Once you lose the sentence man you can't complete it. मागुर कोन डाकली
राहुल बहुत मैटर होगा जो
petitioner shall move for bail petitioner
मुक्सल डाकी थिल exactly कौन लेकिन the petitioner which in custody shall move for bail if before the learned court in session of the matter and shall be released on bail on such terms and conditions that would be deemed fit and proper by the learned court disposed of accordingly. The certified copy of the orders as produced in the court taken on record na फेरी भी
ना recorded
आगे recorded था वो नहीं as deemed fit and proper
urgent
certified copy as per rules. Order sheet तो लगेगी. This order sheet could not be tagged because it was signed late yesterday. Late माने कॉल गया अपन पढ़ देले मैटर ता थिला हो.
नहीं किया
Sorry.
उपजन नहीं किया चाहिए
ता संगरे सेटा रहइबो
302 या भी थोड़ा
among doubt कोन रहले shall be granted bail on subject on such terms and conditions as would be deemed fit and proper. Yes, next. से एक सेतबेले दिव्य प्रकाश मिश्र पौडे अर्जन करछन्ती देखंतु 42 49 equal to 42 बरहमपुर जोटा
may play loss.
Yes.
22B 12 kg 900 grams of ganja. It will seized from the rented house of the petitioner.
So Santosh Kumar Mahanti for the petitioner. आपन 25 वाले आर्म्स एक्ट अछि
No, that has the bail allow हो जाय छै एटा रिमांड करछन ए केस रे they have remanded in the present case loss. और सिमिलर ऑफेंस केस भी नहीं.
Yes, Mr. Mahanti.
Yes. Below commercial quantity.
Below commercial quantity.
Yes.
जहाँ भी लोअर कोर्ट रिकॉर्ड भी से कहउछन्ती ऑर्डर से.
Yes.
मिस्टर महांती वर्सेस महांती ठीक है. संतोष कुमार महांती एसके महांती वर्सेस पीके महांती AC. The learned counsel for the petitioner the petition under section 439 of the CRPC has been filed by the petitioner who is in jail custody in connection with
Rambha PS case number 2.
Rambha PS case number 228 dated 30/3/2024 pertaining to special.gr case number 09/2024 into bracket N. In the file of the learned additional sessions judge cum special judge High Court dash comma Ganjam. The learned counsel for the petitioner submits that the petitioner is in custody since
30/3/24.
In the meanwhile, final prosecution report has been submitted.
Final
No instruction. Sir, in the meanwhile, the katontu. It is submitted that considering the period of incarceration, the petitioner, the prayer for bail will be sympathetically considered. Stop. It is submitted that the petitioner is a local person having roots in the society and shall subject himself to the jurisdiction of the learned court in season of the matter and shall abide by the terms and conditions that would be imposed if the court is inclined to grant bail to the petitioner. The ASC referring to the section 38.
37.
Section 37 of the NDPS Act and the nature of allegations opposes the prayer for bail. However, it is not disputed that the bar and also as referred to in the order of the learned court in season rejecting the earlier prayer for bail dated 21/5/2024, the quantity of contraband seized is 12 kg 190 grams, which is below the commercial quantity. Para. Having had learned counsel for the parties, the learned counsel for the petitioner as well as the learned AC, this court is inclined to grant bail to the petitioner subject to petitioner directing that subject to such terms and conditions that would be imposed by the learned court in season of the matter. We shall include the following conditions. Two local sureties, lordship. So the 10 condition lage debe tate. Hala?
Subject to verification of the criminal antecedent. Subject to verification of the criminal antecedent.
Similar सेटा डाइसी हबो ताले बेटर हबो रहिबा एटी से आपण आनिबे इंस्ट्रक्शन स्पेसिफिक. You see, whenever the court is not sure of the part, so it is better to avoid that.
Item 55 also same affair another court ki
55 रे केतेटा एंटीसीडेंट अछि
नहीं सिमिलर ऑफेंस अंडरस्टैंड
से 12 किलो 190
हां से एक एका सेम affair और अदर कोई की
एटा केते नंबर आइटम आपण करछन
55
Yes, my lord.
55
Yes, my lord.
next matter is
नहीं प्रेजेंट मैटर होची 50 आइटम 50
प्रेजेंट 50 इक्वल 55 सेम 55 ने मिस्टर महांती यू आर देयर.
Yes, my lord.
आपण आउट सबमिशन जोटा लिखलेनी कि पिटिशनर को गोटे लाइन ऐड करंतु देयर इज नो allegations of that there is no similar allegations against the petitioner in the past. The submission ta record kar diyo.
Problem.
Yes.
51. Item 51, may I please your lordship?
Yes.
Petitioner is in custody since 21/3/2024.
Mr. Bhupendra Mahapatra, Dhirendra Kumar Mahapatra for the petitioner. Yes. The maximum punishment kete ki?
Maximum punishment so far 57 is concerned, it is 14 years.
Life?
No, only 14 years. 14 years RI.
14 years RI?
My lord. Maximum. And the 3 so far is concerned, it is 7 years, my lord. Allegation against the present petitioner along with 2 others say that, my lord, they have break the shop room and theft away 5 numbers of tire. That is the allegation. And all the tires has been recovered from another person, that is Suraj Mani Jena, who is the owner of the Tata AC pickup van, my lord.
Allegation, first allegations called.
So for the rejection or concern is implicated to one case, that is Amba Bhava PS case number 214 of 2023, offense under section 379.
कितने दिन पहले?
My lord, since 21st March.
2024?
Yes, 24 months.
अब 20 दिन में 14 वर्ष ये 10 वर्ष लोग जाई पार नांदी द पनिशमेंट है इंस्ट्रक्शन आनंद तो
Yes.
फर्स्ट पैराग्राफ लिख ले the petition under section 439 of CRPC has been filed by the petitioner who is in jail custody पूरा complete कर ले second the learned counsel for the petitioner submits that the petitioner is in custody since
21st March
21/3/2024. In the meanwhile, the final prosecution report has been submitted.
Yes, your lordship. Submitted.
On?
That is, I have not last 10 days, but I am not sure about the date, my lord.
In the meanwhile, the final prosecution report has been submitted. And the petitioner be granted bail. The learned ASC in response submits that he may be accommodated to obtain up-to-date case diary instructions, past allegations of criminal activity against the petitioner, if any, as prayed for, list in the week commencing A के साथ है ना 8 साथ है
मतलब एक साथ
A के साथ है 2024 before the assigned bench oblique when moved the learned AC shall obtain चाहे लिख लें सेटा obtain the details as indicated above कर yes
my lord.
Mr. S. Das, Satyajit Raut, Mr. S. Raut. Mr. S. Raut for the petitioner.
On behalf of Amla Panda.
On S. Raut on behalf of A.R. Panda for the petitioner. Mr. Mahanti, P.K. Mahanti, AC for the state. Yes.
My lord, 20B2B of NDPS Act, my lord, 12 kg of ganja. Custody since 23/5/2024. No similar type of antecedents, my lord. If your lordship will, if and no antecedent of similar nature, my lord. And local person, my lord.
Yes, Mr. Mahanti, she doesn't refer, the learned court doesn't refer to any past allegation?
No, my lord.
Very strict ହେଇଗଲେ ହଉ ତାହେଲେ ସେମ୍ ଆଜ ଇନ୍ ଏଟା 50-55
yes
ନାଇଁ କି କେତେ ଡାକିଥିଲେ ସେଟା ତା ପୂର୍ବଟା
ଆଇଟମ
ଆପଣଙ୍କ ବାଟଟା ଏବେ କେତେ ଚାଲିଛି 52 equal to 50 ତା ପୂର୍ବ ବାଟଟା କେତେ ଥିଲା 45 ନା
no 55
ଆଚ୍ଛା
yes my lord.
ଆଚ୍ଛା ଠିକ ଅଛି 52 is equal to 50
yes
also equal to 55 yes next
Publishment.
से 10टा कंडीशन पकाई देबे सब गुडा करे ହେଲା
Beg pardon, my lord. Item number 53. I am audible, your lordship.
Pin करंतु हां yes 53
I am audible, my lord.
Mr. T.K. Sahu for the petitioner. Mr. P.K. Mahanti, AC for the state. Yes, Mr. Sahu.
Yes, your lordship, the occurrence take place on 25th April 2024. On the next day, that is on 26th April, the complainant logs the FIR against one Anand Samal and Misra Babu, your lordship. These two petitioners are the FIR named accused, your lordship. Thereafter, my lord, based on the confession of one Yasubanda Singh Samal, Jibanananda Samal apprehended in this matter, my lord. And based on the statement of Jibanananda Samal, the present petitioner apprehended in this matter, your lordship. That means the co-accused statement, the implication of the petitioner is co-accused statement, my lord. He is the first offender. There is no criminal antecedent, your lordship. The present petitioner forwarded under section 464, 465, 468, 471, 474, 420, 34 of IPC. All are
how much money was?
The allegation against two accused person is, my lord, 25,000 and 25,000.
Total amount, not this case. In these kind of matters, you have to 17 lakhs.
Beg pardon, my lord.
17 lakhs has been collected from how many persons?
My lord, the present petitioner saying from him only 50,000, 25,000 and 25,000 euros. And the petition, the complainant saying 7.
What about the co-accused persons? Have they been granted bail?
No, my lord.
They are in custody.
They are in custody, your lordship. But I am the first offender, my lord. Recently in Satyendra Kumar,
they have got an instruction.
Yes, ma'am.
This kind of matter, there is a difficulty in distinguishing who has done what. There is nothing to distinguish that.
My lord, your lordship, I am only praying one thing, your lordship.
Look at the rejection order. The details have been given that 17 lakhs on so many occasions from so many phones, calls were received. Let them obtain instruction.
Yes,
the first paragraph Mr. Sahoo, the petition under section 439 of the CRPC has been filed by the petitioner who is in jail custody in connection with a complete collect.
Since
the petitioner submits that there has been no past allegations of criminal activity against the petitioner. The petitioner has been implicated as per the statement of the co-accused persons. And in the meantime, final prosecution report has been submitted.
No, not yet. Not yet.
In the meantime, the Katidiyot. The learned ASC, in response to the prayer for bail, submits that he may be accommodated to obtain up-to-date instructions, case diary, past allegations of criminal activity, to apprise this court. As prayed for, list in the week commencing 8th July.
My lord. My lord.
8 July 2024. Public moved by the petitioner. The learned AC shall obtain the details as indicated above.
May I pray one thing?
Yes, please.
My lord, may I pray one thing, your lordship?
Yes, please.
Recently, my lord, in Satyendra Kumar Hon'Ble ratio, your lordship well aware about the Satyendra Kumar Hon'Ble, that is 2023 order, my lord. May I read, your lordship?
Just read my judgment referring to Satyendra Kumar Hon'Ble. You refer to say that but I have referred to it, I have granted a bail referring to Satyendra Kumar Hon'Ble in a GST violation case.
Oh, grateful, your lordship. I will.
So, Satyendra Kumar Hon'Ble, Bafna, and earlier, and the other matter, the latter decision, Satyendra Pare kon asila?
Satyendra Kumar Hon'Ble is the latest one, my lord.
If you have read,
one is the Ernest
Kumar, Satyendra Kumar Hon'Ble, and earlier Bafna, wherever it is there, you just find out the paragraph where the court has power to grant bail without referring to the case diary and obtaining the past antecedents.
My lord.
If it is there, then you find it out that even without referring to the past allegations, for repetitive offender, you see, in a chain of offences, you have duped some 50 people. Satyendra Kumar Hon'Ble doesn't say, Doher says that even bail also at the first instance, the bail is to be granted like a default bail. You are not arguing a default bail petition. We had an interesting discussion that somebody being accused for the third time in a similar offense says that his fundamental right is violated. Then what is the fundamental right?
For the custodial person, there is no
outside after cheating people. What is the fundamental right?
My lord, there is no fundamental right.
No. You see, the right of a person whose liberty has been curtailed is there.
Yes, ma'am.
Inside also custody, he continues to enjoy those rights. That is a distinguishing factor.
Great.
A person's right to live with dignity granted by Article 21 continues even if he is inside custody.
Yes, your lord.
But that doesn't extend to the fact that judicial custody after committing a crime. So there may be a little bit confusion there. Somebody saying that fundamental right, I have to remain free. So it is just a discussion. Since you raised an interesting point, so I say, so there is not Satyendra until that it has to be granted bail like a default bail. It has to be considered. That is I'm noting your submission so that you can reiterate those submissions. That he is now no way implicated. or maybe as far as only one person he is the conduit, or he received the money and handed it over to the principal accused. Perhaps that is your submission, but you did not say that.
Madam.
You said that you are not the beneficiary, direct
Yes,
beneficiary in that sense.
I am the mere employer of that prime accused, Your Lordship.
I understand. So you should have said that. It is not that I have to prompt you to say that.
Madam.
Yes, go on, Lekhle. List in the week commencing 8/7/2024, oblique moved by the petitioner. The learned AC shall obtain the case diary, antecedents, and so on, so on. Yes.
Dreadful, madam.
Yes. What is on record is the rejection order. That rejection order pointed you out, that it gives all details.
Madam.
Yes. Yes, please.
Petitioner custody since 21/3/24. And the NDPS case, my lord.
Mr. Dibya Charan Swai for the petitioner. Yes.
51 kg seized from a vehicle where 3 persons were moving, and I am moving for one of the person. So 51 kg divided by 3 and 17 kg. I have written my
133 kilo
dita car jautala.
So आपण এই जो मैथमेटिक्स এটা কোন প্রভিजन রে ଅଛି যে টোটাল সিজर ডিভাইডেড বাই পিপল সো आपण 100 জଣ নাହାନ୍ତି ତ କାହା ପାଖରେ ରହିବନି पर्सनल कंजम्पशन ବି ହେଇ ପାରିବ
ଦିଟା vehicle ଥିଲା ଗୋଟେ
ସो ସେଟା କଣ ସେଟା ଅଛି କଣ ସେଟା ସେଟା ଯଦି
ସେମାନେ 3 ଜଣ ଥିଲେ ସେ
that interesting argument if it is there in the provision then show that whenever amount the total seizure shall be divided into the number of persons accused divided by 10, each will have a 1/10. Suppose assume 10 jana achanti 1/10 or 1/3 of that.
Which car he is moving this petitioner and 51 kg 25 kg.
So ताहले कोन होई last को ये हबो जे implication now more than 2-3 persons हेई परिबनी then आपण divide कर देबे. It has to be the total amount. It can't be the split up amount.
Total amount 51.
आपण जदि कहिबे जे that both are separate incidents.
Incident
धरंतु दीटा इंसिडेंट हला NS16 रे दीटा गाड़ी सीज हला. गोटे गाड़ी one vehicle was driven by X, other was driven by Y. X and Y are not related. Vehicle owners are different. But suppose it is sent by A divided into two truckloads X and Y, then how do you say that it will be divided by 1/10 ହେଇକି ହବ? ସେମିତି interpretation ନାହିଁ. ଯଦି ଅଛି ତାହେଲେ ଆଣନ୍ତୁ so that this court can think about it.
The petitioner is a businessman. He is moving on a rate for purchasing the business materials. As
doing business is not prohibited actually. Prohibited to the extent
money is also
people are doing business in contraband, sir. Right to do business has some limitation. You can't do business in contraband. कौन करा जाए?
वाटरमैन बिजनेस ପାଇଁ ସେ ପଇସା ନେଇ ଯାଉଥିଲା ସେ ପସିଗଲା.
ଆଣନ୍ତୁ instruction ଆଣନ୍ତୁ.
Yes, ma'am.
Exact role attributable କଣ ଅଛି ଆପଣଙ୍କର କେସ୍ ରେ?
କେସ୍ ରେ 3 ଜଣ
ମାନେ ଆପଣ ଡ୍ରାଇଭର, କୁରିୟର, ଓନର କଣ ଆପଣ?
ପାସେଞ୍ଜର. ଡ୍ରାଇଭର ଯେ ଅଛି ସେ
ଆପଣ କୋଉ ପାସେଞ୍ଜର?
ପାସେଞ୍ଜର. ଡ୍ରାଇଭର ଯେ ପିଟିସନ ଅଫ ଯୋ ରିଜେକ୍ସନ ଅର୍ଡର ଅଛି 3 ଜଣ ତା 2ଟା ହଉଛି ଇଏ.
They were transporting.
That is the allegation.
Details ଆସିବାକୁ ପଡିବ.
Yes, ma'am.
You are moving for Ashok Giri or for all?
Ashok Giri. I am for Ashok Giri. Other top actor I have not moved now.
এটা কোন এটা? কত নম্বর আইটেম?
54.
54.
Mr. Dibya Charan Swai, Mr. Swai. Mr. Dibya Charan Swai for the petitioner, Mr. P.K. Mohanty AC for the state, Learned Counsel for the Learned Counsel limiti ଲେଖନ୍ତୁ ତ. Petition under section 439 of the CRPC has been filed by the petitioner who is in jail custody in connection with PS case number ete, dated ete, GR number ete, pura detail likhibe in the court of the ADJ cum special judge Baliguda in CT 79 of 2024. PS case number 75 of 2018-2024 ହେଲା provision ଟା पर लिखिए पूराटा under section. The learned counsel for the petitioner submits that the petitioner is in custody since 21/3/2024. It is further submitted that the petitioner has no direct involvement in any in the alleged crime, as he was the only passenger in the vehicle carrying the contraband. The DLN charge sheet diyachi. Then the learned additional standing counsel, in response to the prayer for grant of bail, submits that he may be accommodated to obtain up-to-date instructions, case diary, past allegations of criminal activity against the petitioner.
First of all, no criminal antecedent.
ठीक आसु से अपन भी बड़े बड़े जान पाना नहीं से पड़े प्रॉब्लम होची. You are trying it, finding it difficult to get over that. कौन लिख ले? Past CA criminal incident. ना आज paid for list in the week commencing एक के साथ ना 8 साथ है क्या बे? 8 साथ है 2024. The AC shall obtain the instructions and details as directed above. Yes, next please. Sarada Prasana, as per the petitioner, Mr. Mahanti P.K. Mahanti, AC for the state. Yes, please.
Lord, petitioner is in custody since 14/4/2024, my lord. Offense under section 392 of 5 my lord. Court red-handed, my lord. And no criminal antecedent. Petitioner is a lady, my lord. So the charu roy.
Antecedent किसी नहीं कहूँगी.
My lord, paragraph 5, my lord, your lordship may kindly see. It has been reflected the criminal antecedent of the accused is yet to be verified. And also this petitioner belongs to outside state.
Mr. Das, you know, the trained in this court, not said by me, said by the other coordinate benches. You find out somebody to file affidavit who will be the local surety tago. 5 मास 6 मास जाउची सेमती पड़ी रहउची. You do something which will expedite the matter. I can ask them to obtain instruction. The order that subject to the petitioner furnishing 2 local sureties,
My lord.
should say he period. Labo kon hela tale. So violation to jail. You have to think in that line. Now, upon showing to initially, more the assignment asil October, upon one test call. Good, you tested me. But I said, I am following those decisions of orders of Justice M.S.Sahoo and Justice V. Nursing. Criminal proclivity standard here. But upon the basis, the first plea he is a repetitive regular offender, repetitive offender.
Habitual offender.
And let him off.
Ganja case.
My lord.
এই সব জিনিসের এই পয়েন্টে তো আপন হাউ টু গো তুমি গোটে স্ট্যান্ডার্ড ইভলভ হেলা ইউ ফাইল অ্যান অ্যাফিডেভিট stating the truth. Court has power to grant you, so you state the truth. Let the court consider and decide. That's the sole purpose. But ଆପଣ ଗୋଟେ ଡିଭାଇସ୍ କଲେ ଆପଣ କୋନି ମାନେ ଜେନେରାଲ ରେସ୍ପଣ୍ଡ ହେଲା ଯେ ଆମେ ଜାଣିନୁ ସେ ତ ଜେଲରେ ଅଛି ତାହେଲେ ଲେଟ୍ ହିମ୍ ଷ୍ଟେଟ୍ ଅନ୍ ଓଥ୍ ଯେ ତା ପାଇଁ କିଏ କହିବ ଯେ ମୋର କିଛି ନାହିଁ ବୋଲି ଲେଟ୍ ଦେମ୍ ଇନଭେଷ୍ଟିଗେଟ୍.
Let him obtain instruction ମାରଣ
ଆପଣ ଆଣନ୍ତୁ ଏବଂ ଲୋକାଲ୍ସ ଇଏ କିଏ ତାଙ୍କର ହେବେ ତାଙ୍କର ଫ୍ୟାମିଲି ମେମ୍ବର କିଏ ଲେଟ୍ ଦେମ୍ କମ୍ ଟୁ ଦ କୋର୍ଟ. Let him file affidavit. Appearance section le na the petition under section 439 of the CRPC has been filed by the petitioner who is in jail custody since 14/4/2024 in connection with लिखिए पूराटा लिखिए कितना नंबर केस था in GR case number 935 of 2024 in the file of additional session judge Barampur.
SDJM Barampur, my lord. Rejected by additional.
In the file of SDJM Barampur, GR number 935 of 2024 in Barampur town PS case number 144 dated 14/4/24. The learned counsel for the petitioner submits that the petitioner is a lady and is in custody, and considering her prolonged custody inside jail, is entitled for bail. दिया सलानी ये prosecution जानना थी. The learned AC, in response to the prayer for bail, submits that he shall obtain up-to-date case diary instructions, past allegations of criminal activity against the petitioner. Accordingly, the list in the week commencing 8/7/2024. 17 ladies अपन तो किसी करू ना आंती 17 the court will be in that fix. Outsider snatching अपन बरहमपुर जाके चेन छिंडेबे वेस्ट बेंगल वासी की अब आउटसाइड को इनसाइड को आगे बरहमपुर आउट 100 किलोमीटर गले अपन आउट स्टेट को पड़ेगा माय लॉर्ड. तो this is a problem.
17 था I will try my best.
I got your prayer. And it's a matter of concern that once they are in custody, they are remaining because nobody is looking after them. Family, they are abandoned by their family. That you must also realize.
My lord.
If you try to get those details, then you will have an idea.
My lord.
1/7/2024, list in the week commencing 1/7/2024, public moved by the petitioner before the assigned bench.
My lord.
The learned AC shall obtain the details as indicated above. Yes.
57.
Mr. Mahesh Das. 56 वाला अपन नंबर भूल लिख ली अपन आरंभ कोठू गले कोट से आरंभ गले मिस्टर बारिक 54 प्रथमटा 55 ऑलरेडी सॉरी लेनी 56 मिस्टर दास शारदा प्रसाद दास लिखिले तापर 57 मिस्टर महेश दास
57 here we had 8 kg of ganja and he was a local person and here so far as the rejection order
rejection ने भी किसी लिखा है नहीं
criminal antecedent nothing मिला 8 kg बोले लिखा है ची local person and 37
अपन किसी नेलेनी बेल नेलेनी कूटा नहीं चली कहीं 55 तो से नहीं ना तब डाकिया पड़े ठीक है. Mr. Moise Das for the petitioner, Mr. P.K. Mahanti, AC Ekepati. I'm sorry. What a bubble is say. Upon the Chidavan, the Kawana recognition. Upon the separate to Kayaside. Mr. Akshay Kumar Patti, Akshay Kumar Patti for the AC for the state. The petition under section 439 of the CRPC has been filed by the petitioner who is in jail custody. In connection with 2 into bracket small a C.C. case number 26 of 2024 in the court of special judge dash additional district judge, the additional district and session judge, Baliguda, arising out of PYC of Excise, Raikia, PR number 17 of 2024-25. It is submitted by the learned counsel for the petitioner that the petitioner seeks indulgence of the court for grant of bail. As the quantity of contraband seized, alleged to have been seized from the petitioner is 8 kg, 500 gram, 8 kilo 500.
8 kg.
8 kg, which is below the commercial quantity. The petitioner being aged about
31 years.
31 years should be given a chance to come back to the society, to the normal life that would help him in view of the allegations. That would help him in rebuilding his life. Stop. It is submitted that the petitioner is a local person having roots in the society, shall subject himself to the jurisdiction of the learned court in session of the matter and shall abide by such terms and conditions that would be imposed if the court is inclined to grant bail to the petitioner. Para. The learned ASC referring to this provisions contained in section 37 of the NDPS Act and the nature of allegations approaches the prayer for bail. The PR has final hint. Para. Having heard learned counsel for the petitioner and the learned ASC, considering the material on record, this court is inclined to grant bail to the petitioner subject to such terms and conditions that would be imposed by the learned court in session of the matter, which shall also contain the following conditions. Disposed of accordingly, so 10 condition दे देवे. तापर लिखिए to default to what लिखा हो नहीं. Expression shall not be treated as expression of the on the opinion of opinion on the merits of the case. Yes.
58. My lord, after vacation, my lord put up one move.
Amlan Shakti Pal for the petitioner, Mr. Akshay Kumar Patti ASC for the state. The learned counsel for the petitioner seeks accommodation to obtain instructions and advance arguments as prayed for list after vacation when moved by the petitioner.
59.
May I please?
You are Mr. M.S.Sahoo.
Sahoo, man. Sarveswar sir.
Sahoo. Mr. Sahoo for the petitioner. Mr. A.K. Patti, ASC for the state. Yes.
My lord, offences under section 20B2C, challenging the judgment passed by the learned court below, the appellant has filed this petition. And
appeal admit
no, my lord. This has to admitted.
Can you speak to the microphone?
This has to admitted.
First time.
My lord, first time has come, my lord. LCRB call for.
It a single bench matter ki?
My lord.
Achha.
10 year conviction is 10 years.
So the appeal has been filed. कितने बार item दाखिल किया उधर?
59.
The appeal has been filed. 59 ठीक है लिखो तो. The appeal has been filed by the petitioner, having been convicted by the court of sessions judge cum special judge Malkanagiri in special English 2 into bracket small a bracket closed C capital number 30 of 2023 arising out of Kalimera Excise Station PR number so and so देखिए लिखिए convicting the petitioner, convicting the appellant लिखिए the सबूतरे appellant अब the appeal has been preferred by the appellant देखिए the convict the appellant imprisonment for a period of 10 years.
10 years.
10 years.
And to impose a fine of rupees 1 lakh.
And along with imposition of fine.
1 lakh rupees.
Hard issue notice. Hard admit hard then admit then तापर issue notice. LCR be called for. IA 1245 of 2024. And 1247 of 2024. Issue notice as above. The prayers made in both interim applications shall be considered after receipt of the LCR. First, you hard admit issue notice. The learned ASC appears for the respondent state and waives notice. Copy of the appeal memo has been served on the ASC. Sir, condition. I issue notices above cordianto. On a ASC appears, the prayer shall be considered para. List in the we come the petitioner shall have the liberty to move for consideration of the interim prayers after receipt of the LCR. Yes.
May I plead your lordship?
Yes.
I'm on behalf of Jagjivan Pradhan.
On behalf of Jagjivan Pradhan. Yes.
Today, lordship, the appeal has been come for admission, lordship. It's a appeal against conviction. Conviction of 10 years, lordship.
Civil bench hochi. Mr. Pati? Das?
No, notice to be called. Pokso hochi.
10 वर्ष कम सिविल बेंच एडमिट हो
10 years below 10 years
below 10 years single bench
any prescribed punishment or imposed punishment question the different
imposed punishment
that is the criteria same order thale apna 59 रे जो order टा कले 60 रे से exact same order Miss Pradhan Miss Mahanti you have heard the order in 59
my lord
I will lie over and will be considered after LCR is received.
My lord.
One doubt call a bit Yes. Next.
I need to.
So Sahoo 61.
My lord. May I
just speak to the microphone, Mr. Sahoo. Yes.
My lord. My lord, this petition is filed under section 482 of CRPC, challenging the order in not allowing me the challenging the order dated 8/5/2024, my lord.
Yes.
Because I have filed one petition under section 167 subclause 2 of CRPC, but the learned STGM did not consider my prayer and rejected the prayer.
LCR be called for.
Yes, Mr. Pati, you said something.
LCR be called for. His prayer is there.
My lord.
His prayer is also there. LCR to be called
yes,
for.
Yes.
पच्चीस ଦେଇଦେଲେ ଚାର୍ଜସିଟ୍ ଫାଇଲ ହେଇଗଲା ପରେ କଣ ରହିଲା
no my lord
ଆପଣ ଲାଟେଷ୍ଟ ଡିସିଜନ ଟା ଦେଖିଲେ କନଷ୍ଟିଟ୍ୟୁସନ ବେଞ୍ଚ ର
my lord they have not given the charge sheet on that date they have
you are disputing that
yes my lord for that reason I have filed CRMC otherwise I have
ବର୍ତ୍ତମାନ କଣ status
they have committed the
deferred bail ରେ जो ଲାଟେଷ୍ଟ ଜଜମେଣ୍ଟ ଦେଖିସାରିଲେଣି it can be recalled actually that is a limited liberty granted.
But I have filed 167 subclause 2 after 135 days. That is statutory report 120 days.
You just obtained the exact instruction from the learned counsel who was appearing in the lower court. You are not appearing for trial, but the court has recorded that the charge sheet is submitted on 25
No, my lord. 2023 he has wrongly submitted, my lord. Wrong submitted. My lord.
Actual error the court record.
I have submitted this.
It is part of the court record.
My lord.
ଆପଣ ଯୋଉଟା କହିଲେ କେମିତି ଭୁଲ ହେଲା ସେ କେମିତି କହିଲେ ଠିକ ହେଲା ଏମିତି କେମିତି ହବ
My lord.
Issue notice.
My lord, kindly come to
hard the learned counsel for the hard issue notice the learned ASC appears for the state and extra copy of the petition has already been served. The copy of the petition has already been served to enable him to obtain instruction. Call for the scanned copy of the LCR.
LCR as well as order sheet, my lord.
Including the entire order sheet.
My lord.
ଆପଣ ସେଟା ସାର୍ଟିଫାଇଡ୍ କପି ଆଣି ପ୍ରଡ୍ୟୁସ କରିବାର ଥିଲା
Copy, sir, commitment.
on the face of it you are not making out a case what you are saying may be correct but on the clearly ଲେଖିଛନ୍ତି clear finding ଦେଇଛନ୍ତି
Well, kindly come to pay.
anyway ଆପଣ କହୁଛନ୍ତି ତ ସେ ପରେ ଆପଣ କହୁଛନ୍ତି 135 ଦିନ ପରେ ଆପଣଙ୍କୁ ଫାଇଲ କରିଛନ୍ତି ବଟ୍ ଆପଣଙ୍କର 24 ରେ କମ୍ପ୍ଲିଟ ହେଲା 25 ରେ ହେଲା 135 ଦିନ ହେଲା କି 140 ଦିନ ହେଲା କଣଟା ହେଲା
He has wrongly written that. I have fast up.
I got your point but I am discussing since the order is very clear in on that कौन लिख ले order sheet the learned AC shall also obtain instruction list before the assigned bench in the week commencing केबे
after vacation
after 8 ना 15 8 7 20 24 सर्वेश्वर साहू Mr. Pati, Akshay Pati, yes.
62.
Yes, please.
Please, my lord. My lord, the allegation is under section 392 and 34 IPC, my lord.
Yes.
The name of the present petitioner is not in the FIR. It is one of the co-accused, my lord, who has disclosed the name of the present petitioner, my lord. And then after he is arrested, my lord. And the money which is seized, that was from the co-accused, not from the present petitioner, my lord. He is no way related, my lord.
She did ask. It adjust को bench रहे लगी को थ्रे तो लगी. It earlier order टा को थ्रे तो लगी. Not पांच है डता justice Mr.
it लिखा है ऊपर order से.
और 17-5 रे लिस्ट ही पानी. ताले इटा तो आसिया का था नो.
There is IA also, my lord. One of the family member has also died. One of the family member of the present.
IA पे ऐसी.
Yes, my lord. IA is also there.
सीटा instruction ना पूरी वजह किच करी होगा.
Your lordship, in this case, I have put the informant, your lordship.
Upon instruction,
your lordship, within a short period of time, I cannot file the.
Mr. Ashish Kumar Mishra for the petitioner. Mr. Akshay Kumar Patti, AC for the state. तापर लिखंतु IA 662 of 2024. On 9/5/2024, report the BLAP लिखिए बुझिले कि on 9/5/2024 the matter was taken up by the coordinate bench. The BLAP was taken up लिखंतु. The BLAP was taken up by the coordinate bench and the following order was passed. Thereafter the IA has been filed on typically
my lord, just 2 days before, my lord.
Chari.
Chari
4/6/24 and the matter has been listed 4/6/24 with an interim prayer for grant of interim bail.
Copy note, please.
Copy of the said application we served on the learned state, the learned counsel for the state to enable him to obtain instruction.
Yes, my lord.
The learned counsel for the petitioner submits that he shall serve copy of the petition during course of the day to enable the learned state counsel और डिटेल किसी देना है ना पा देना है कौन ये किसी कोडी कौन चाली वाले आप लेकिन जरा किसी देबे नहीं
well that is annex, my lord.
At least must know what court is there.
Annex, my lord. Annex one is there, my lord.
अपन petition लिखियो नहीं
that is mentioned.
कौन लिखले कौन करछोंदी मु बुझ पान से के कौन रिलेशन सेमती दियंतु
no particular
I doesn't give the details of the particulars of the person who has died.
Who's the grandfather of the
person?
What is it?
Person which person?
Yes, my lord. The
कौन लिखले sentence पढ़ंतु such as name of the person, detailed address, though it has been only mentioned that grandmother, single quote, which person? Single apostrophe जो अपना apostrophe inverted comma single रखिबे, grandmother inverted comma closed of the present petitioner has died. The petitioner shall furnish the details of such person. केबे सुधा देबे?
By tomorrow, mother. By tomorrow with the memo.
Within 3 working days, along with a memo before this court, copy of the memo shall be served on the learned counsel for the state. ଆଉ ତାହେଲେ ହବ କଣ? ଆପଣ ତ ଦେବେନି କିଛି।
କାଲି tomorrow
କାଲି ଦେଲେ କଣ ହବ? କାଲି ତ ଇଏ list in the week commencing
the next vacation court ମାଲେ
କେମିତି ମୁଁ କରିବି? କଣ ଆପଣ ତ ଦେବେନି, ଆଜି ତ ଡିଟେଲ ଦଉନାହାନ୍ତି ଆପଣ।
ଦେଇଛି ମୁଁ
Sir, I am not to run after, the court is to run after.
I'm sorry, I'll give the details.
There is a possibility ଆପଣ briefing counsel ଯେ lower court counsel ଦେବେନି, ସେଟା ଆମେ କଣ କରିବୁ ସେଟା? How can you expect that they will obtain? List in the week commencing 18/6. Please, the petitioner have after filing of such memo and the details. कौन लिखले पढ़ंतु काटी लिखंतु कोड को लास्ट टा पढ़ंतु कोड सारे ले गया स्टेट होला तापरे लिखंतु the petitioner shall have, if such memo giving all the details is filed, affidavit diontu, if memo no affidavit shall file affidavit giving the details, the petitioner shall have the liberty to move before the vacation bench. Complete kale mu date doni because I do not matter. तापर लिखूं तो अपन नाटा सर
M.S. Hassan.
Mr. M.S. Hassan. Musaddiq na कौन?
Muqam Hassan.
Muqam Hassan.
Acting for the informant, Your Lordship.
Mr. M. Hassan submits that he has instructions to appear on behalf of the informant in the present matter. He shall file his wakalatnama by tomorrow, which shall be taken on record, scan copy be updated. Name of Mr. Hassan be upon janchen to FIR fever janchen na ke ko FIR ko dure ka file person that figure nahi.
I know, but I have taken instruction that no person has been died from his family, Your Lordship.
Hey, Sirbashi detail de nahi. If somebody would have died, he would have given the details.
Yeah.
So that we par.
While PI parrot, the main accused person has been identified, Your Lordship.
Identification for trial for identification for heart attack ହେଇଯାଇଥିବ କଣ?
Your Lordship may not be.
ଏଜେଡ୍ ଲୋକଙ୍କର ଯେ ଶୁଣିଥିବେ ତାଙ୍କର କାରନାମା ଶୁଣିଲା ପରେ ତାଙ୍କର ଗ୍ରାଣ୍ଡସନ୍ କି ଗ୍ରାଣ୍ଡସନ୍ ତା ହାର୍ଟ ଆଟାକ୍ ହେଇଯାଇଥିବ। ଠିକ୍ ଆଇଡେଣ୍ଟିଫିକେସନ ପାରେଡ୍ ହେଇନଥିବ ତାପରେ ଗଲା ଆଉ କଣ ଲେଖିଲେ? Indicated in the cause list as well as the case brief. ତା ପୂର୍ବରୁ ଲେଖିଲେ ସେ taken on record, scan copy be updated. फाइलिंग समय पड़े बाय टुमोरो लिखले ना बाय टुमोरो करंतु अपन ऑफिस टाइम जानछन तो 12टा जाय बोली 3टा जाय ऑफिस टाइम फाइलिंग टाइम होची 12टा यस डेट मु केम देबी सी मूव करिवे ना मु जदी डेट देबे और लिस्ट हे परियो ने
नेक्स्ट पब्लिश
अपन instruction नेबे इन द एसी कोन इन द मेन फाइल सी कॉपी देनंदी कोन instruction से कोन नेबे इनके से आगे फाइल करन तो तापर देखियो 63 yes Miss Sahu
63 I'm on virtual mode, my lords.
Yes, please.
My lords, I have filed an application at flag K for modification of the order, my lords. Your lordship was pleased to grant me bail, but there is one bail condition, my lords.
Yes.
Your lordship, page 3 of the order, your lordship is directed for 2 solvent sureties. One of them has to be a family member. My lords, the difficulty is that family members are brother and sister. None of them have any ROR in their name, which is why it is being difficult to...
That you have to file there. There will be a consideration that on that ground there will be rejection. Then it can be modified.
My lords,
Magistrate.
My lords.
Please look at that order.
Yes, my lords.
Order dated 6/5.
Yes, my lord. 6/5. 6/5.
Just kindly turn to that portion.
Yes, my lords.
The last but page 3.
Yes, my lords.
2 solvent sureties. Kindly look at that. For an amount of satisfaction, just read the subpara.
2 solvent sureties for an amount in the satisfaction of the learned court in session of the matter. One of the sureties shall be a family member of the petitioner.
I am referring to the next para.
Yes, my lord. The court in session of the matter shall ensure and verify the credentials of the sureties. The court shall direct and record its satisfaction.
So that the court has to give. Unless you get that order, so that is the reason I have been repeatedly telling that please don't negotiate on these conditions, because these conditions have been well thought of. Some kind
Yes,
of
my lord, yes.
being
Especially in these cases.
assisted by the learned counsel. So these have been thought of.
Yes, my lord. My lord, then I'm not pressing the IA. I'll not press the IA.
Ms. Sahu, the other part is that is how I tell. It is better to file the affidavit on behalf of the sureties so that it is verified, sent and verified, so that this problem will not arise.
My lords, my lords.
We are there in some matter where the person from West Bengal, we do not know. So by putting the condition at times, it doesn't solve the purpose also.
My lord.
IA पकेबे এটা IA এটা কত নম্বর item 63 Sagarika Sahu for the petitioner. IA copy পাইছেন আপনি? Yes. Mr. Akshay Kumar Patti AC for the state. Yes, Mr. Patti, what is your response to Ms. Sahu's?
Again, she have to move there. After that disposal, she have to come.
Because there is no, as such, there is no record finding to that effect. That is my understanding. Yes. Mr. Patti, the IA election, IA 654 of 2024. The learned counsel for the petitioner doesn't want to press the IA. The IA stands dismissed as not pressed. Yes. Yes, pass over? No. Thank you. Thanks for your time. Yes.